There's lots of coffee in the back, so make sure you juice up, because 3 hours is a long time to sit and listen to anyone. Just some quick housekeeping before we get started. If it gets too hot or cold, there's a temperature gauge. Just wave your hand, I can go and change the temperature. We're constantly trying to get this room to be the right temperature, which doesn't ever seem to happen. There's coffee in the back. If you need to use the restrooms, it's right through here. They'll be on your left-hand side. So I'm Katie Radis. David Blaine was supposed to do this presentation, but he went away to Camp Keep, so I'm David today. This is sort of an advanced wage and hour seminar, and the idea is we do lunch and learns on little discrete topics, but the idea is we want to put everything together in one very thorough and very comprehensive program, and so that's why it's so long. It's actually divided into 2 sections. So I'm going to get through a portion of this today. Whatever we don't cover in this session, we'll cover in the next session. Okay, so if you have questions, don't be shy, raise your hand. You know, we're not really beholden to any particular schedule. I'll try and cut off for a break at some point, just because I think 3 hours is too long. You guys will go to sleep. But anyway, so please don't be shy. What we're going to start with, this might help. We're going to start with a dance routine. No. What we're going to start with, this is just an overview of all the information that's contained in here, okay? These are the big sort of topics that we're going to hit on between today's session and the next session, okay? The sort of basics, when we talk about the basics, what laws actually apply. There's a lot of overlap, as you are probably aware, in California in terms of the federal laws, the federal court decisions, the labor code, the wage orders, the labor commissioner's regulations, the labor commissioner's enforcement manual, you know, and then we have our state cases. So there's a whole bunch of sort of pieces to that puzzle, and that's really your starting point, okay? What actually even applies? Then we're going to go through, when we talk about wage and hour law, there's the hour piece, okay? What do we actually have to pay for? Which hours are compensated? How do we calculate those? How do we define those? The work week, the work day, all that kind of stuff. On the other side of that is the wage piece. How much do we have to pay? When do we have to pay it? Okay, and there are very particular requirements, particularly when we talk about things like final wages and all sorts of stuff. If you were to go and pull out the labor code, which no one will probably do, but you get this 2 huge volumes, and they are chock full with by the 26th day and by the 15th day, and these very particular requirements. So that's what we look at when we talk about the hour side. Then we're going to talk about overtime sort of as its own separate piece, because we see a whole bunch of case law, a whole bunch of claims that pipe up or that pop up with respect to overtime. How do you calculate that? How do you calculate that when you've got somebody who's working multiple pay rates? You know, what do you do if you've got somebody who's traveling and then working and now they have bumped into overtime? Okay, and then some ways around overtime, whether it's alternative work week schedules or make-up time or other things you can do to sort of cut those costs down. Strategic compensation looks at the different pay structures. You could pay somebody a salary, you could pay somebody an hourly rate, you could pay them on a piece rate basis, you could pay them a commission. They're all different kinds of compensation models that are available. And if you understand sort of the pros and cons of those, you can use that strategically so that you really create an actual incentive that doesn't end up costing you, thousands of dollars in overtime and everything else. But you need to be very sort of conscious in that decision of how, everybody just sort of assumes, oh, well, if they're non-exempt, I'm just going to pay them an hourly rate. Well, that may not be the best decision for your business. You may get a lot more bang for your buck if you were to include some sort of bonus payment or something. Okay? There are costs to, in employment law, we say that no good deed goes unpunished. Okay? There are costs to using incentive plans as a means to change behavior or as a means to incentivize your employees. Okay, and so if you recognize those costs, how much is this going to increase things from a practical standpoint in terms of calculating the payroll, from an administrative standpoint, tracking that time and so forth. If you can weigh those against the benefit you're going to get from that compensation structure, then you can make an educated decision as to what's the best payment plan for your people. Okay, and then finally pitfalls. All right, I can talk all day long about you've got to do this and this is the requirement and the blah, blah, blah. In the real world, that's not always how this stuff plays out. Okay, you have the guy who shows up and says, oh, I never clocked out last night, so now he's got a time card that says he worked 24 hours. Okay, what do we do? How do you fix that? All right, and those are the things that are going to come up in real life, and that's typically the calls that we get. All right, I've got somebody who's on leave and wanted to use all of her paid leave and blah, blah, blah. Okay, whatever the case may be. So we'll go through those. I think it says top 10, but I think there's actually more than 10. So we'll hit on as many of those topics as we can. But we're going to start at the beginning with the basics, okay? And these are the sections we're going to cover in basics. What are the agencies? What are the laws? What are the regulations? Okay, is the employer covered? Is the employee covered? And then we're going to look at a wage order. You know, we always talk about what wage order you fall under, and I'm always surprised when the client calls, oh yeah, okay, we're under this wage order. They've never looked at a wage order. They've never read it. I mean, they're thin. They're probably about 8 pages, okay? I mean, and it's not written in some crazy language. It may be a little hard to decipher because there's some legalese thrown in there, but really they're not that scary or intimidating, okay, if you sit down and read through them. So we're going to go through the different provisions just because I think most people aren't real familiar with what's actually in there. Okay, so the laws, the regulations, the agencies. If any of you were at the Lunch and Learn last week, David used an example of a tree. Okay, if you think about the laws as like a tree. And it's a really good example. The labor code, well, before we get to California, I want to talk about there's federal law and then there's state law. Okay, all the states have this. We have 2 competing bodies of law. The federal law sets the bare minimum. Okay, this is the baseline of what you have to do. All right, and then states can add extra protections if they want. All right, and California, our great state, okay, of course we have more employee protections than any other state in the country by far. All right, one of the most heavily regulated states, and it's not, you know, and certain industries really feel that, but particularly when it comes to employee rights, employee protections, wage protections, and so forth. I have a lot of clients who have multi-state operations, okay, and they'll call and say, well, we got this guy in Texas, what are we going to do? You know, if you're paying him according to California law, I guarantee you you're going to be complying with Texas law, okay, and that's true of almost every other state. Okay, there may be some little nuances and differences, but for the most part, California by far the most employee friendly. So if you think about it as a tree, okay, federal law is, you know, it's the new development somewhere where they stick the tree in and it's like a stick, okay, and it looks like that. And those are the federal protections, okay, and then state law, you know, is the giant oleander, you know, in Westchester or whatever that has been growing for 100 years that is huge and, you know, 100 feet tall. Okay, and those are the state protections, all right? So if you compare those two, typically the employee is going to fall under that giant oleander tree, okay? It offers a lot more protection, okay? They're the little bird, and they fly to the tree. They're going to go nest in the big, huge tree, okay, where there's lots of stuff, lots of leaves. So when we talk about that big oleander tree of state law, if you think about the trunk, the branches, the sort of base of that tree, that's the labor code, okay? That's, you've got to provide a meal period. You've got to pay your employees, you know, if biweekly or semi-monthly if they're non-exempt, or weekly. You've got to, it's the sort of big mandates of what you have to do, all right? But there's a lot of other pieces to that tree, okay, particularly the leaves. And the leaves are like the wage orders, the regulations. It's all the detail. How do you actually ensure that an employer is complying with whatever that big mandate is in the labor code, okay? In addition to the branches and the tree and the trunk and the leaves, okay, there's also, I don't know what you'd say, fruit, flowers or something in the tree, okay? And that's the labor commissioners. That's the enforcement policy, okay? This is how we're going to look at these problems. If an employer comes in and says, we only pay, you know, we pay a travel rate and then we pay their shift, and they've still only worked an 8-hour shift, and I don't care that they spent an hour traveling. The labor commissioner is going to say, well, no, they actually worked a 9-hour shift. They traveled for an hour, then they worked for 8 hours. That's 9 hours. Our enforcement policy is that we're going to look at that 9-hour window and we're going to require overtime. Okay, that's the little flower. This is their manual of this is how we're going to resolve these issues. This is what we're going to do. So a lot of times when you guys call me, you'll say, well, I'll tell you, well, this is what the law says. Okay, and that's all fine and good. But here's what the labor commissioner is going to tell you. If somebody marched down to the DLSE and filed a claim, this is what they're going to say, okay? And sometimes there's a disconnect between what the law says, okay, and what the labor commissioner says they're going to do. A great example of that is with the meal and rest periods. Okay, the labor code said you have to provide a meal period, okay, 30-minute, uninterrupted, duty-free, all that good stuff. All right, provide a meal period. And so when it trickles down to the leaves and down to the fruit, the labor commissioner says, well, provide means you need to ensure that that meal period is taken. Okay, and that's what we operated under for 15 years. And everybody fought over, do I have to have a timesheet that shows that the meal is actually taken? And the labor commissioner said, absolutely yes. Provide means ensure that it's taken. All right. Finally, we had an employer who was willing to fight this. Okay, it went up, and it went all the way to the California Supreme Court, and the California Supreme Court in the Brinker decision said, no. Provide means you give them an opportunity to take that meal period. If they elect to not take it, then they didn't take it, But as long as you, employer, are allowing them that opportunity to take the meal break, you've satisfied the requirement that is contained in the word provide. Okay, so that's an example of where you see labor commissioner doing something that's a little different than maybe what the leaves and the trunk and the tree are all requiring. Okay. When you get that disconnect, okay, it comes down to a business decision. Do I want to ensure that I am, complying with what the labor commissioner says so that I can, save the money and not have to spend money to defend my practice? Or do I want to stand on principle of, no, this is not proper and this is what the law requires and that's what I'm going to go with? Okay. Most of my clients will opt to just do whatever the labor commissioner tells them they're going to do so that they can, cut out the possibility of a claim down the road. All right. At any rate, so we have the labor code. Okay, that labor code is going to be enforced by the Department of Industrial Relations, the DIR, and then under the DIR we have the labor commissioner. That's at the Division of Labor Standards Enforcement, the DLSE. So if you've ever gotten those little notices in the mail, I was supposed to be at the DLSE this morning, somebody says they didn't get the right overtime or they didn't get their final wages, all of those claims will go there. Okay, that's a separate body from other agencies we have, like there's one here and one there, and there's one back there, sorry. No problem. We're a friendly group, you're fine. So that's a separate group from like the Department of Fair Employment and Housing. Okay, if someone said I was fired because I'm a woman, or I was not hired because I'm, whatever, a lesbian, whatever they say. Okay, they're going to file those claims at the DFEH, the Department of Fair Employment and Housing. If somebody says, hey, I need to take time off and I want to get paid for that, or I'm disabled, they would go to a separate agency, the EDD. Okay, so there's all these different avenues. But when we talk about payroll issues, when we talk about wage claims, okay, they're going to start typically at the Labor Commissioner's office, that's the DLSE. Okay, they don't have to go there. They can go straight to court, but 9 times out of 10, they're going to start with the Labor Commissioner. And usually the Labor Commissioner is going to be even more favorable, like I mentioned, than the state laws. Okay, so those are the laws we have. We have the big federal law is the Fair Labor Standards Act, before I move on. So that's our big federal law. Again, it's like the little stick, okay? There's no daily overtime. There's just not a lot in there. There's no reporting time obligations. There's a bunch of stuff that's not in that Fair Labor Standards Act. On the state side, we have the labor code, and then we have the wage orders. Okay, and depending on which wage order you fall under, you're going to have different obligations that you need to comply with. Okay, so we figured out what the laws are. All right. The next question is, are you covered by the laws? All right. This is the place where we need to start. All right. I just had a discussion with a client who's in this room. Okay, where we went through this whole analysis. Oh, baby bonding leave, X, Y, and Z. Okay, you need to do this. Oh, there's all these specific requirements. You have to allow it in shorter increments than 2 weeks on at least 2 occasions. And they get up to 12 weeks. And here's the forms and back and forth. Oh, wait. They don't have 50 employees. They're not actually covered by FMLA and CFRA, so we didn't even need to go through any of that analysis. Okay, this is where you need to start. Are you covered? Does this law even apply to you? Think of it like a credit card. Okay. If the store doesn't accept credit cards, I don't care what the regulations are with respect to what you can buy or not buy with your credit card, okay? Even if the store does accept credit cards, okay, but you don't have a credit card, I also don't care what the regulations are with respect to what you can and can't buy, okay? Credit cards aren't an issue if you're going to a store either that only takes cash or where you can only spend cash, okay? So it's the same with these laws. All right, if this is not a law that's going to apply to you, employer, then we don't care about it. Okay, if this is a law that applies to you, employer, but guess what, the employee isn't covered for some reason, then again, we don't care about it. Okay, so when I talked about the federal law, the little stick tree, and then the big oleander tree, okay, when there's a disconnect between those two, the law most favorable to the employee is the law that's going to govern. Okay, that's why the little bird is going to end up in that big, huge tree, all right, generally. There are certain areas where federal law will preempt state law, okay? They're pretty slim. We're looking at arbitration agreements are one that's now coming up as a preemption issue. ERISA issues. There are some things like that that are going to be covered specifically by federal law. Okay, if you've got drivers that are regulated by the DOT, okay, that's an example. That's a carve out. They fall under federal law, and we don't worry about any of these state protections. Okay, but again, those are the exceptions rather than the rule. Okay. Usually when we talk about whether a law is going to apply to you, okay, for most of our laws we have this sort of number of employee threshold, all right? And some laws will look at, we'll consider a part-time employee an actual employee. Some will say, okay, 2 part-time employees equals a full-time employee. Okay, some say, well, they're a full-time employee, but they need to have worked there for a certain number of hours or for a certain length of time. Okay, and then some laws just kick in the second they walk through the door. Okay, talk about things like, workers' comp or pregnancy leave. I might, be pregnant 1 second after I arrive at work. Guess what? I'm covered. Okay, that actually did happen at my first job. I showed up like 4 months pregnant, which I'm sure they were thrilled about. But at any rate, that number of employees is often going to be a trigger, and it was a trigger for the situation I had, earlier or last week. Okay. All right, so is the employer covered? When we talk about the Fair Labor Standards Act, there's individual employee coverage. I'm going to get rid of this. Enterprise coverage. Government employers are going to be covered under that Fair Labor Standards Act. Okay, religious nonprofit organizations. That's really your carve out for the federal side. Okay, on the state side, pretty much anybody who's in the private sector is going to be covered by those state wage and hour laws. Okay, there's a carve out for government employees. Okay, or special districts, things like that. They might find a way around this. But for most of us, we're going to fall under this stuff. And so that's why we have to pay attention to it. Okay, so assuming you're covered, say we're all private employers, we're all going to be covered by these wage and hour laws. The next thing we look at is this employee covered. Okay, and the wage and hour laws apply only to employees. Okay, only employees. So when is somebody not an employee? All right, we start with that presumption. If you're going to argue that someone's not an employee, the burden's on the employer to prove that that person's not an employee. And how do they do it? They prove that, they're a volunteer. They prove that they're an independent contractor or a partner or a shareholder. Or, it's you prove it's your kid and they're cleaning the room. Okay, that's not going to be covered by the labor code, all right? There are certain exemptions. Some of them are written in the statute and some of them have evolved via case law. Okay, but the big ones you're going to see typically are volunteers and independent contractors. There are some other sort of what they call special employment relationships. If this is a member of a religious order, they may be exempted from certain things. If this is a trainer or a learner, okay, that's the first 160 hours of work that someone does in a particular field, you can pay them at a decreased rate. Okay, if you've got a temporary employee, usually that temporary or leased employee will be an employee of both the temp agency and the place where they're actually doing their work. Okay, so they can file a claim potentially against both. Each may have separate obligations. The temp agency may be the one who's on the hook for the workers' comp, is what usually happens, okay? But in terms of the actual employment relationship, it's going to exist as between both entities. Okay, it's called dual employment. Interns are up there also. You can have interns that aren't paid. Okay, I was at a seminar not too long ago, and the guy said the way to tell if someone is an employee or an intern is whether or not they're a pain in the neck. Okay, if they're a pain in the neck, and this is really bothersome and cumbersome, then they might be an intern. Okay, if you're receiving some benefit from them and they're working out great and they're doing their job, then they're probably an employee. Okay, that's not the real test, but that will get you probably 90% of the way there. We had about 2 or 3 years ago, they relaxed the standards with respect to interns. Okay, and they used to have a big, when I say they, this is the labor commissioner, had a big 12-part test to decide if someone was an intern in order to meet the California standard. And nobody met the standard. There were no interns, okay, so everyone's getting paid. All of a sudden, we had a court case that said, well, those are too onerous. Those standards aren't right. We're going to go with the federal test, when it comes to deciding if someone's an intern. And there are like 6 factors. Are they getting a benefit? Things like that. Is there some, school credit or something like that that they get from this service? All right. So as soon as we see those standards relax, everybody says, hey, great. You guys are all interns now. And guess what? You're not getting paid. Okay. So we had a whole bunch of this big onslaught of employers trying to use interns all of a sudden when historically they hadn't. And whenever you have a big onslaught of activity, okay, it turns into a whole bunch of case law. Okay, so now we have all these intern claims. And if anybody ever comes to Legal Update, I usually get 2 or 3 cases about, oh, guess what? The Fox interns weren't interns and the, whatever interns weren't interns. So you want to be very careful about that. Okay, they really are kind of clamping down on that. Even though the statute and the regulations have relaxed, the courts have sort of clamped down on that. Okay, that's the piece that was sort of missing when I talk about the laws. We have the big tree. You also have the courts that come in. And I guess that's the tree trimmer. Okay, they come in and shave things up and say, well, it's actually going to work this way. Okay, because that's another piece that we need to be mindful of. You might have a statute that operates one way, is enforced one way, and then here you get a court decision that says, oops, that's not the way we're going to do it anymore, and we all have to now follow what that court says. As we go through this, when we get to areas where there have been new developments in the case law, I'll make sure to highlight that stuff for you. Okay, because that's one of the pieces that sometimes gets left out. It's hard to keep up on. I mean, that's all I do for my job, and it takes me a full-time job to do that. All right, for those of you who are also trying to run a business, in addition to keeping up with every case law change, every new regulation, and so forth, it gets to be pretty cumbersome. So we start with the presumption that this person is an employee. Okay, and if I want to not treat them like an employee with respect to wage and hour laws. I don't want to worry about their meal break. I don't want to worry about their travel time. I don't want to worry about workers' comp, all this kind of stuff. Then I need to prove that they're not an employee. Either they're a volunteer, typically, or an independent contractor, or a partner, I suppose, or a shareholder. Volunteers. Okay, volunteers are people who do work with 0 expectation of payment. Okay, and typically this needs to be something that's for a humanitarian service, a religious service, some sort of public benefit service. Okay, I might really like Jeff Thorne and say I'm going to volunteer to come to work and give presentations for free. Okay, I can't do that. All right, that's not something that's of a voluntary service. And what happens is you have employees who come in and say, sure, I'd love to volunteer to work at the company picnic. Great. I want to do this because I just love everyone we work with and I love to plan parties, so I'm going to volunteer to do this in my spare time. Well, maybe they really are volunteering. Maybe there is no expectation. Okay, maybe this is for a public benefit, at least to the extent of your workers. What happens is, okay, 6 months down the road, you write them up for something, they get mad, and they go down to the labor commissioner and say, well, guess what? I spent 40 hours planning their company picnic, and I didn't get paid for any of it. All right? And they remember it a little differently, okay? And it's pretty easy to make that argument that, well, when my employer asks me to do something, I feel obligated to do it, okay? Even though they're saying, sure, I'll run the, summer skip program for free, or sure, I'll do this. There's a little bit of an expectation because as the employer, you're in a position of authority, okay? When I worked at a local firm, the partner came in and said, hey, we're all going to, Luigi's to meet with a new client. I go. It's the partner I work for. Okay. Plus I love Luigi's. That's usually not a hard sell. But the point is you need to be careful. You need to be careful with those volunteering employees. Okay? And a lot of times it'll be your good workers that are saying, oh no, I don't mind. I'd love to stay after and stuff the envelopes, okay? Or get the Christmas wreaths for the clients. All right, be careful. If they're doing something that you're deriving a benefit from, okay, and they're a regular employee of yours, 9 times out of 10, they're not going to be deemed a volunteer, okay? If it's something that, typically it needs to be something that is totally separate from what the employee usually does. Okay. If I'm a CPA, I can't volunteer to do other people's taxes at my employer's place of work. Okay, that's not going to work. That's exactly what they're paying people to do. Okay. Independent contractors. Okay, so volunteer is one way to get out of that employment categorization. Independent contractors is another one, and this is pretty common. Okay, I get a lot of, well, we'll just 1099 them because they're creating problems. she's, you know, whatever, slips and falls all the time, so we don't want her on our workers' comp, so we'll just 1099 her. And she agreed to it. She said that's totally fine, and we signed this contract. In fact, we slit our finger and we signed it in blood. Okay, great. I don't care. I don't care what you guys contract. There are certain provisions you cannot contract around. Okay, one of them is employment status in terms of whether or not someone's an independent contractor. You may both agree that may be fine and good and dandy. Okay, but the law says if that person is actually an employee, they're an employee. There's nothing you can write down that will change that. Okay, that employment relationship needs to be such that they truly are an employee. It's just like if we wrote a contract that the sky is purple, right? We all sign it together. That does not make the sky purple. It just makes us seem crazy. All right. When we talk about independent contractors, even though everybody wants them to be an independent contractor, they aren't going to be an independent contractor unless they actually truly are. Okay, and when are they truly an independent contractor? Okay, who knows? The cases are all over the place. All right, 2 years ago I did a legal update. UPS drivers were independent contractors and FedEx drivers were not independent contractors. Okay, this stuff changes all the time. All right, and part of why it's very hard to tell if someone's an independent contractor is because this is very fact-driven. You can have one or two little facts that will change the entire outcome. All right? What they generally look at is the level of control that an employer exercises over that employee. Okay? Do I tell you when your schedule is and approve your time off and tell you when you're going to get paid and show you how I want you to do the presentation? Okay? Or do I call you on the phone and say, hey, the air conditioner's broken, can you get it fixed? And you decide when you can come and how you're going to fix it and how much it's going to cost and send me an invoice at the end. Okay, it's very different. I've got a lot of clients who have independent contractors that turn in time cards. Okay, that's not going to be an independent contractor. That's going to be an employee. Okay, have them turn in an invoice. Scratch out the word time card and write invoice at the top. You know, but those are the things they're going to look at. Okay, and a lot of these relationships have just one or two little facts, again, and they can turn on something very small. All right. We had I think it was last 2 years ago, the penalties for willful misclassification of somebody as an independent contractor went way, way, way up. Okay, it is anywhere from $5,000 to $15,000 for the first violation. Okay, and 15 to 25 for repeated or pattern of violations. Okay, pattern and practice, they call it. You know, $5,000 penalties are huge as compared to what we typically see. Typically in the labor code, you know, the first violation will be $100, and then every violation thereafter will be $200. Okay, now you're talking about $5,000, you know, $10,000 fines. That's huge. All right, if you're a large company and you decided to make everybody independent contractors because you're going to save so much money, now every single one of your workers potentially might expose you to a bunch of penalties. You can see how expensive that stuff gets. Okay, because it gets so expensive, and because if you're misclassifying one person, you're probably misclassifying everybody else in that category. Okay, this is very, very attractive to the plaintiff's bar. Okay, they want lawsuits where there's going to be huge penalties and where there are a lot of people who have problems, because that's when they get to file a class action. Okay, and that's when they get to come back and say, guess what, you owe us $30 million, we went back 4 years, and blah, blah, blah. Okay, so it's an easy way to get tripped up. Make sure if you've got independent contractors that they absolutely, truly are independent contractors. Okay, I can't stress that enough. And I really do, I mean, I probably get one of these a week where they say, oh, well, it's fine, you know, we'll just 1099 her. Well, that's my guarantee of employment. There you go. Okay, when we talk about the basics, we're going to talk about those wage orders. Again, I want to just march through these. I'm not going to talk about each one of these provisions because this is something that we'll get to later on. We're going to go through each piece that's contained in those wage orders. When we talk about the wage orders, there's 17 wage orders in California. Okay, there are 3 occupational, 13 industry, and 1 miscellaneous. You need to figure out which wage order is going to apply to your business. I have a lot of clients that will fall under multiple wage orders. Okay, they're under 9, but also 16. They're under 4, but, you know, 16, or 4 and 9, or whatever. Okay, if you have questions about that, you can go to that DLSE website, and there's a little printout that they do that says, which wage order am I under? Okay, it's kind of generic. It doesn't go through every single iteration of who you've got, but it will give you an idea. You know, if you click on nurses or something. It'll say you might be under 4, you might be under 5, it gives you the options. Okay, so it's useful to look up if you're having questions. You can also give us a call because this is a question we regularly get. Your wage order or wage orders, if you've got more than one, need to be posted at work. Okay, so if you got the wrong wage order up there, you're going to be in trouble from a posting standpoint also. Okay, not to mention that you're probably doing everything wrong if you're following that wrong wage order. Okay. So what's in a wage order? And I use wage order 4 because this is one that applies commonly to most of my clients. Okay, it's the clerical office setting type of wage order. Okay, it's going to have a provision in there about overtime, what the daily overtime is, when double time kicks in. Okay, there's information, section 3C or whatever, that's all about the alternative work week schedule, how you implement it, what you have to do. Okay, this is a good example of how things differ because if you're under wage order 16, you might look at that alternative work week paragraph and it looks a whole lot like the alternative work week paragraph in 16, but guess what? There are like 5 extra little words here and there that make a huge difference. Okay, so you want to actually very thoroughly read this stuff. I'll give you a great example of why it's important to read things carefully. It was a case that we had, it wasn't here, it was in Florida, I think. It was a discrimination claim. Girls, she files a claim. They reach a settlement, draft a release. We're going to give you this severance package, and you're going to release all the claims. Okay? She says, great. I'm not going to, I'm going to release all my claims, including discrimination and harassment and gender discrimination and sex discrimination, blah, 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 all this stuff. Okay? They work out their release agreement. It's sort of a standard form. Send it off to her. She goes in, changes including to excluding. Okay? Yeah. Signs it, sends it back. They look, okay, all the lines match up. Oh, great. Looks like the same document. Great. They sign it. Give her big, fat severance package. Yeah. 3 months go by, and she goes in and files her lawsuit. And they say, well, wait a minute. You signed this release. And she says, yeah, I signed that release. I release all claims, excluding gender, sex, blah, 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 all the things she's now filed her lawsuit for. Okay, and the court said, that's fine. That's fine. You had the opportunity to read that document before you paid the severance package. She evidenced an intent to preserve those claims. Okay, so those little tiny words, that was 2 letters, made a huge, tremendous difference. Okay, it's really the case with the wage orders too. Okay, there are very minute discrepancies as between these sections, so it's really worth reading. Okay, so what else is in wage order 4? There's a special exemption for some of the commissioned salespersons. Okay, and we'll talk about those when we get into that exempt analysis. There's inside sales and outside sales, and what do you have to do to meet both of those? Provision about child labor laws, the requirement of 1 day's rest in 7. Okay, graveyard shift meal facilities. If you got somebody working the graveyard shift, they have to have a separate place where they can go and sit down and eat. That's all contained in the wage orders. Collective bargaining agreements. An exception for DOT people. Again, that's one of the areas where we have federal law that's going to preempt state law. Okay, somebody's covered by the DOT, that's the law that governs, and we don't care about the rest of the stuff. Okay, a 72-hour weekly maximum in terms of hours worked, provision about makeup time, minimum wage, a split shift premium. Okay, when you can use that split shift premium to offset your minimum wage obligation, reporting time pay. Licenses for disabled workers, and that sort of goes back to that learner rate. Okay, there are certain times when you can pay a sub-minimum wage. Record keeping, cash shortage, breakage. When I talk about breakage, this is your stuff that gets ruined by the employee. What can you do about that? When can you, put those costs back on the employee? Uniforms and equipment. Okay, and we just had a whole lunch and learn that was all specifically about the uniforms and equipment. We'll hit on some of that again in this session as well. Meals and lodging. If I provide somebody with a meal, when can I use that to offset my wage obligations? Meal and rest periods, changing rooms, resting facilities. Seats. Okay, this is an interesting one because it was one little section, I think it's paragraph 13 or 14. It's in every single one of the wage orders. Okay, the employer needs to provide reasonable seating if the nature of the work would enable the person to sit down or something along those lines. Okay, I think it says the employer shall provide reasonable seating where the nature of the work would allow the employee to sit. Okay, it's been in the wage orders since they came out. All right, and about 3 years ago, maybe 4 years ago, we had some clever attorney who got the idea that, hey, if you're a cashier at Dollar Tree, okay, and there's nobody in the store, but you're standing behind the cash register, then you could sit. And guess what? The employer didn't provide a seat. Okay, they file their lawsuit, they win, and now we see this huge flood of the seating claims. Okay, Bank of America and Kmart and Nordstrom, everybody's been hit. Okay, Rite Aid. They're just finally starting to make their way up to the actual, higher courts where you were getting some sort of precedential decisions. And the ground rules seem to be that if you'd have to, reconfigure your whole operation, you don't need to provide, you don't have to remodel every single store. Okay, that was out of a Kmart decision. We had another case where the employee had never requested a seat. Okay, and the employer said, well, we didn't provide a seat because they never asked for one. The courts have said that's not a sufficient defense because the wage orders say you shall provide. They don't say the employee shall ask. Okay, so that defense isn't going to work. We had another one that just came out last year that dealt with product demonstrators, and so they wanted to be able to sit when there was nobody there to sample their product. You go to Costco and they're like, have a cheese tart or whatever. Okay, those people, the court said, the nature of their work is such that they need to be standing. Okay, they can sit during their rest breaks and they can sit on their meal periods, but really the nature of their job is they need to be standing there and engaging with the customers. Okay, so they were not entitled to seats. But it's a really good example of just that careful, close reading of the wage orders. It's something that had been missed for years and years and years. All right, so don't think that just because the stuff's been around for a long time that we're not, still potentially looking at a firing line here. Okay, provisions about elevators, exemptions that are recognized by the Labor Commissioner, reports, inspections, all the penalties that are associated with violations of that wage order, okay, and then your posting requirements. Again, remember the wage order needs to be posted as well. So those are the big topics and items. That was bullet by bullet if you picked up a wage order and read it. When we talk about the labor code, there are 5 primary labor code sections that we're going to be concerned with. Okay, section 201 deals with final wages, when you have to pay that, what that needs to include, and all that sort of stuff. 203 is what happens if you don't pay wages. Okay, we've probably heard us talk about waiting time penalties. Okay, when do waiting time penalties kick in and what do they attach to? Waiting time penalties, typically up to 30 days pay. Okay, a lot of people think, okay, that's a month of pay. No, it's 30 working days. Okay, so it's really more like 6 weeks of pay. So if you mess something up, guess what? They're not going to come in on the first day that you mess it up. They're going to come in on the 31st day, okay, after you've messed that up, 31st working business day. 204 is the payday obligations, posting your payday and when the payday has to occur, whether this person is exempt, non-exempt, all those. When I talked about those very specific timing requirements, a lot of those are in 204. 207 is the posting requirements, and then 226, your wage statements. All the little pieces that need to be in that wage statement. And again, we're going to touch on these things individually, but these are the big labor code sections. Okay, when you get that problem, somebody says my wage statement is wrong, you can go look at labor code section 226, and 226A specifies every single one of the little things that needs to be in there. Okay, don't presume that your wage statement is correct just because you have somebody who's doing your payroll. Okay, I have spent lots and lots of hours going back and forth with the client to their payroll provider saying, look, we've got to break out these separate rates, we've got to break out this, we've got to show the weighted average, we've got to show it per week, we've got, it's not necessarily correct just because you're having somebody else do it, unless it's WorkLogic. If WorkLogic is doing it, then it's correct. No, I'm just kidding. But that's something to be mindful of. Okay, go back and look at that stuff. Okay, so that was the basics of what the laws are. All right, are there questions about any of this stuff? I tend to talk pretty quickly, so if I'm rushing through stuff, then slow me down. That's fine. Okay, so we're going to talk about wage and hour law. We're first going to start with hours. What are the hours that we're concerned with? Okay, and these are the big topics we're going to hit on. Hours worked. How do we define that under both federal law and state law? Meal and rest breaks, and then some of these special considerations, whether it's standby, on-call time, travel time, all that kind of stuff, and then finally tracking time. All right, what do we do with the employee who just will not fill out that timesheet? Okay, or they fill it out and it's totally wrong. or the supervisor fills it out for them, which seems to happen more often than not. Okay, so under federal law, okay, and this is the federal regulation where we get this definition, all time during which an employee is required to be on duty, okay, or they're on the employer's premises or at a designated workplace, and time when they are suffered or permitted to work, whether or not they are doing so. Okay, if they're allowed to work, if they're there and able to work and you're allowing them and you're having them be at your work site or you're telling them to be somewhere, even if they're not doing anything, okay, I show up for work, clock in, and then I just lay on the floor. Okay, guess what? I'm at work when you told me to be there. If I'm not actually working, okay, that's a performance issue. All right, I can get written up for napping the minute I walk through the threshold of the office. Okay, that we don't discipline people with their pay though. That is still an hour worked even though I didn't actually do any work. Okay, so that's something you want to keep in mind. Under state law, okay, it's the same sort of thing. It's a little bit broader, the way that the courts have defined that. Okay, suffered or permitted to work, or subject to the control of the employer. And when we have subject to the control of the employer, that's where we pick up all of this extra stuff. Okay, the big case that we had that dealt with hours worked was this Marillion case. And there they had guys who, they didn't want to have any car, they would drive them out to a lease, I think. They didn't want to have them drive their own cars out there because the people didn't want all these 50 cars out on the lease. And so they said, okay, everybody meet here, you're going to get on the company van, we're going to drive you out. Okay, employer thinks this is great, we're saving them gas, we're driving them, we're, this great ride that we're giving them. Okay, here comes the lawsuit. The employees say, I showed up for work the minute I got to that parking lot and got in that van, because that's where the employer told me I had to be. The employer was paying them once they got to the actual job site. Okay, and the court said, if you're requiring them to be there, you're telling them they need to get in that van, they are now subject to your control, and that's when the workday starts. Okay, the workday starts at that first principal activity. Okay, and if the first principal activity is getting in the car that they're required to get into, then that's when the day starts. All right, so it's something to remember. And the way you get around this, because I have a lot of clients who don't want a whole bunch of cars out on the lease and also don't want to pay everyone for the hour and a half it takes them to get out there on the company van. Okay, what you do is you make that voluntary. We will provide transportation for you if you'd like to get on the bus. Be here at 5 in the morning to get on the bus. Bus is leaving at 5:15. It'll drive you out to the lease. Okay, great, super. Most employees will opt for that voluntary transport because they do want to save the money on gas. Okay, you don't need to pay them though as long as it's voluntary. Okay, the only person you got to pay if it's voluntary is the guy who's driving. Okay, he doesn't get to volunteer to drive. Remember. All right, it's company car, he's going to be on the clock, and that's when his day is going to start. The other time where I see this come up, and I've had this come up twice in the last week, is if you've got a guy who, is the driver. Okay, so he's driving the van, we're paying him, we're paying him this travel rate because, he normally makes 30 bucks an hour, so we're going to give him $10 an hour while he's driving. Okay, so he has his drive shift of an hour, then he goes and he works his 8-hour shift. Okay, and then he drives home for an hour. So the problem is, if you're paying him the $10 when he drives in the morning, then 8 hours of straight time because he worked an 8-hour shift, and then he drives home again, we pay him another travel rate of $10 an hour for that drive home. He's actually worked 10 hours that day. Okay, you don't get to have a shift. It's not daily overtime of a shift, then plus some other work that we're going to allow them to do. Okay, if they're the driver and they start early and they work a full shift, they are going to bump into overtime. Okay, I mean, depending on what that shift is defined at. But yeah,
I have a question.
Nicole.
There's something in Wage Order 16 that talks about not being able to pay somebody less money after their shift has already started. So in other words, you can pay them a reduced rate of pay for their travel time there, but then if you have them work and then go to subsequent locations, do you think that would apply to the ride home, to the travel time home?
Well, there's a few things. Wage Order 16 is sort of its own special beast. You've got a whole bunch of very different and specific things. I'm not sure about the drive home. I do have a lot of clients that still pay a reduced travel rate on the way home. The problem that you run into on that way home also is that I don't get to pay overtime based on that travel rate. And I have a lot of clients who,
Oh, no, we.
yeah, so say they drive for an hour, okay, they work 7 hours because you didn't want them to get into overtime, then they drive home. Oh shucks, this is their 9th hour, they're not on a 980 schedule, this is an overtime hour, and since they're driving, their drive rate is $10 an hour, they want to pay the overtime rate at $15 an hour because that's time and a half of the travel rate because that's what they're doing driving home. You don't get to do that. You need to take a blended rate of what you look at their hourly rate plus the other one. But Wage Order 16, I think we will get to in that second half because not every rule, but a lot of the rules are very different when you comes to the, whether it's the final wages, whether it's the alternative work week, whether it's the, it's its own separate.
We're just trying to do some restructuring, and so it just
Yeah.
came up as you were talking about this.
Yeah. Well, and I know there are other things if you've got somebody on like a prevailing wage job, things like that, where you're not allowed to decrease that rate. But those are all the special cases. Okay, so we look at when they actually first have to be there, okay? And that's going to maybe vary from employee to employee, okay? If you've got a guy who has to be there to unlock the gate and open up the gate for everybody, okay, his day may start way earlier than everybody else, all right? He doesn't clock in to unlock the gate and then unclock or clock out for the next, 40 minutes because we don't want to pay him for that time. Once his day starts, okay? If he unlocks the gate and then works and loads up ice on the truck and then drives somewhere, that travel time to the job site is going to be paid because his day has already started. Okay, if I tell another employee, you just meet at the job site, okay, there's that Portal to Portal Act. I don't have to pay for travel time when somebody leaves their home and goes to the job site. Okay, but if I'm telling them to go somewhere else first and then go to the job site, all of a sudden I have to pick up that travel pay there. Okay, we'll talk about travel as a separate sort of section, but there are some various nuances to that. And that's one of the areas where what the law says is one thing, and what the Labor Commissioner says is something totally different, okay? And the Labor Commissioner's enforcement policy, I mean, they really sort of made it up out of whole cloth. It's not found anywhere in any regulation or in any statute that I've ever read. But that's their enforcement policy, and that's really sort of what a lot of people go by. But so we'll talk about travel at a separate piece. But for right now, when we talk about hours worked, whenever that day starts, it starts, okay? And it may start by something that doesn't really look or feel like work. Okay, if it's the employer telling you got to be somewhere, that's when the day is gonna start. Okay, so how many hours did they work, and why do we care about that? We care about that because in California we have a daily overtime requirement. Okay, so I need to look at how many hours so I know when they're going to kick into overtime. Okay, so we start it at that first principal activity, and it's going to end at whatever time they end. One of the cases we're seeing now that have come up are like the donning and doffing cases. Okay, does the day start, if I tell you, you need to come and you need to put on your protective gear to start your job. Okay, well if you arrive at work and you got to put on a fire retardant suit and a hard hat and your goggles and your gloves and does your day start when you start putting that stuff on, or does your day start when you actually get to the line where you get blasted with fire or whatever you do? If it depends on what, if the first principal activity is donning and doffing clothing, okay, and there's a significant amount of time that's involved in putting this gear on and the safety equipment, then that's probably going to be what starts their day. Okay. The other cases we're seeing are the security checks. Okay, Apple got hit, I think Nordstrom's, and those are, you go through your workday, okay, I work at Apple, and now my shift is over, so I clock out, and I'm leaving the store, and they say, oh wait, before you go, open up your purse, we got to make sure you don't have a bunch of iPads in there, okay? And I stand there for 5 minutes, they look through my stuff, and then I leave. Most retail establishments have a security check before you leave, okay? And the big argument now is, or the cases we're seeing, is that, hey, that time when they're looking through my bag is not being compensated because I already clocked out. Okay, and so maybe it's 2 minutes on one day, but maybe I'm getting off at the same time as these other 3 people, so we're all standing there waiting for our bags to be checked, and maybe I wait for 5 minutes. Okay, does 5 minutes seem like a long time? No, but 5 minutes over the course of a week is 25 minutes. If you round up, that's a half hour of pay. We do have case law that says up to 5 minutes a day is not de minimis time. That is time that would have to be compensated. Okay, that came from a case of a guy who installed LoJack into people's cars. And so he'd run around and, install the LoJacks, and then he'd get home and get on his computer and plug something in, and his computer would, upload the data to the LoJack mothership in the sky or whatever. And sometimes when he'd plug in, he'd get booted off the internet, and he'd have to log back in, and okay. And so he said it took him anywhere from 2 to 5 minutes, but he wouldn't know if he was going to get booted off the internet or not. Okay, and he did that every day while his computer is sending the data. Okay, he's watching TV and drinking a beer, and the court said that was compensable time. His day had not ended until he was done with that, and 5 minutes a day was enough to trigger that obligation to pay somebody. Okay, so you want to make sure you really look at capturing all of those hours. Okay, whether it's the guy unlocking the gate, all the way down to the girl opening her purse at the store to make sure she doesn't, have a bunch of loot in there. Okay, so when we figure out how many hours they worked, okay, unless we've got some exception under makeup time or alternative work week or some other exception, we figure out how many hours they worked. Typically, if they're over 8 hours in a day, they're going to need to be paid overtime. Okay. A lot of my clients will have a prohibition against unauthorized overtime. You're not allowed to work overtime unless it's been pre-approved by your supervisor. Okay, it's a way to sort of control those overtime costs because I don't want employees out there running up the overtime. Okay, that's fine to have that prohibition. Okay, what's not fine is to not pay them when they work that unauthorized overtime. Okay, so I'm the non-exempt employee and I need a little extra cash, so they close the building and I stay here all night long and work for 12 hours all through the night. Okay, then I come in and I turn in my time card and oh good, I'm going to get this big, fat paycheck this week because I needed extra money. And the employer says, you were not allowed to work that overtime. We're not paying you for that. You didn't do any decent work anyway. You were too tired. Okay, they don't get to deduct for those overtime hours. What they can do is write me up. Yeah, this is a performance issue. You're not following our policies. You're not allowed to just run up with overtime. Okay, so you better not do that again or else we're going to fire you. Okay. So that's how you handle that problem. You don't discipline people with their paycheck. If they work the hours, whether they should have, whether they did anything good, whether you liked it, okay, or not, you got to pay for that time. Okay, what you want to watch for when you get the non-exempt employees, okay, and they work their shift, okay, and then they go home and they've got their company phone, and they check their email, and they, text their coworker, and they follow up with something. Okay, that time is hours worked. Okay, be careful giving, those kinds of devices, whether it's a laptop or a tablet or an iPad or a smartphone. If you give those to your non-exempt people, okay, make sure you have a very strict policy of you're not to use this during your off-duty time, because that's one of the #1 ways that they run up overtime costs and they come back and say, well, of course they knew that I was doing it because they got the phone bill and they saw the email. Yeah, Bill.
You bring up a great point. It's a company device, I get it. What happens if employees use their personal device, but on company business, contacting, following up, execution, sending documents, emails, but it's their device?
But it's their device.
It's after hours.
That's still going to be hours worked. It's still going to be, and if you're getting those emails, this is a non-exempt employee, it's 10 at night, and I'm getting, 4 emails from her, and she's my great worker because she's working at 10 at night, okay, that you have to sit down. That's not, you cannot be doing work at 10 at night. Okay, you do that work during your shift. If you don't have enough time to do your work, okay, then that's a management issue. We need to talk about staffing concerns and whatever. But I don't want you doing that stuff at night. Certainly, and when it comes to the smartphones and that stuff in particular, we used to have a lot of claims where the employee says, well, I worked 1,000 overtime hours. Of course, there's no way to actually prove that, all right? And so they march into the labor commissioner and say, well, it's not on my timesheet because the employer told me not to write it down, but I did. I worked all these hours. Okay, if they can come in with their smartphone and show the 10 emails and the 10 texts, and I had to read this email, and I had to do the research, and I had to follow up, blah, 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 and they can show that record of work, it's pretty hard to dispute that. Okay, and if that work is coming to you as the employer or supervisor, then you're on notice that they're working that time. So you absolutely do need to still pay for that. Okay. Be very, very careful giving any kind of, electronic thing that would allow somebody to telecommute to a non-exempt employee. Okay, because they can really run up those costs. Okay, meal and rest breaks. So you have to provide, remember provide means now provide an opportunity. Okay, it doesn't mean ensure that it's taken, it means provide an opportunity on non-exempt employees with an uninterrupted, duty-free 30-minute meal break before the end of the 5th hour of work. Okay, that's what the law says. Before Brinker, it used to be you could just look at a timesheet. Oh, look, there's no meal period on here. Okay, employer, get your checkbook out. All right, we don't have that situation anymore because the employer can now say, well, they may not have taken that meal period, but that was their own choice. There was certainly an opportunity for them to take it. Okay, so the way that these claims are coming up is the employer or the employee says, well, there wasn't an opportunity because they scheduled me so that there was no chance for me to actually get a break. Or my replacement person who was going to come and fill in for me never showed up. Okay, or the supervisor said, yeah, take your meal break, right, whatever, gave me a dirty look, or whatever, did his hand signals that I was going to get in trouble if I took it. That's the argument. You may have frontline supervisors that are saying, yeah, you can take your meal break, but wait, let's finish this job and then we'll take the meal break. Okay, if that job then extends through the 5th hour or the end of the 5th hour, that's when you're going to have a violation. Okay, when we talk about meal penalties, and this sometimes gets confusing, there are 2 payments you need to be mindful of. There's the payment for the time when the employee works, okay, because they work through the meal period. Okay, and then there's that penalty, and the penalty is an additional hour of pay at the employee's regular rate of pay. Okay, those are the 2 pieces there. So if the person works through their meal period, okay, because they want to, because they love to work or whatever, and you've said you can go to lunch, oh no, I'm dieting, I don't want to, whatever, I hate lunchtime, I don't know what. Okay, if they choose voluntarily to go through work through that lunch period, they get paid for the time when they're working. Okay, they get paid for all that work time. They don't get that additional hour of pay. Okay, because it's voluntary, it's on the employee, they've chosen to not take that. Okay, if they work through the meal period, because the supervisor gave them a dirty look, or the scheduling, or the workload, or there was some, disaster, or they're on the rig and they're, whatever. There's something goes on, whatever. They're painting something. They can't stop because all paint will dry. Okay, and they absolutely can't stop. They're going to get paid for that time when they worked. Okay, they're also going to be entitled to that 1 hour of additional pay, that meal period penalty. Okay, yeah.
Document though, if somebody voluntarily wants to work through their lunch hour and you don't pay that premium, how do you prevent them from coming back to you and say, hey, I was working and you should pay me this premium?
Okay, so the question is, how do you document that if the person voluntarily quit that? And I guess underlying that is that somebody might potentially come back and say that they missed the meal period and it wasn't their choice. Yes, people do that all the time. The way you get around that is on your time card. There should be a line that says, in signing this, I acknowledge that I was provided with an opportunity to take any meal period that I was not prevented from taking by my employer. Explain here, give them a bunch of lines where they can explain and document. So when they come back and their time card shows that they started a minute late, ended a minute early, took a really short lunch period, didn't take it at all, it started at the 6th hour. If they haven't documented this was due to a work, what my supervisor said, this was we were working on a job, something along those lines, I'm going to presume that when they sign that time card that that's legit. Okay, and put the ball back in their court. They need to explain to you when and why they were prevented from taking that meal period. Okay, and if you get that in place, you'll start to eventually see a pattern. Oh, everybody who works under Joe does not get a meal break. Okay, well, this is obviously an issue we need to talk to Joe about. Okay, there may be some exposure there, but you want to make sure you have that language on the time card. Okay, it's going to be your best defense. Meal periods can be waived by mutual consent if the person is going to work less than 6 hours. Okay, you want to have that in writing. Yes, I'm not going to take my meal break. You have to provide the opportunity to take a second meal break if they're going to work more than 10 hours. Okay, that second meal break cannot be waived unless they absolutely took the first meal break. Okay, you don't get to waive both of them. All right, but if the person says, I'm not going to take, the first break, then that's fine. Okay, must pay employee for all actual hours worked, but will not owe the penalty unless the delay or the missed period was due to the employer's action. Okay, and that's due to what your supervisor is saying, due to the scheduling, due to the work environment, so forth. Where the meal period is missed or begins after the 5th hour of work due to the employer's action, the employer will owe an additional hour of pay at the employee's regular rate of pay. Okay, I think we've talked about that stuff. One of the things that I want to say again about meal and rest periods, and we saw the restaurant Chipotle got hit with this. You still need to track that meal and rest period, okay, on the time card. That's one of the employee's essential job duties. If they're a non-exempt employee, is doing those timesheets, that time tracking. That is something you can require that they do. And if they're not doing it, that is a performance issue that you write them up for. They need to be doing this kind of stuff. The same is true of the meal and rest periods. Okay, even if, and I have a lot of companies that do this, well, we pay our employees during the meal break because it's just, we didn't want to get sued. It's just easier to pay them. We know it's all covered. It's fine. Okay, but they do take a rest break. This was common in the restaurant industry because you have a lot of employees who maybe don't want to stop working because they want to keep getting paid. So Chipotle's policy was we pay them through the rest break or the meal break, and they give them food too, actually. So they could eat at the restaurant or they could leave or do whatever. Okay, so nobody ever wrote any meal periods down because they're getting paid. So there's no point in documenting this. You know what the point is? The point of documenting that stuff is that the labor code says you have to have accurate time records. You have to document this stuff. Your employees need to be writing that stuff down. Okay, I have a lot of companies that say, oh, well, they're out driving. So they clock in the morning and then they tell us that they got a meal break at some point. Well, I don't want them to call and tell somebody on the phone. I want them to write down so that you have a record so that when they come back in a year and say, I never got any meal periods, you can say, yes, you did. Here's your record. Here's what you signed off on. Here's what you called in on. Here's what you reviewed at the end of the pay period to show that you had these meal periods. Okay, accurate statements. That's the key here. I get a lot of questions about, well, can't we just have an on-duty meal period? Okay, the on-duty meal period is a very, very narrow exception, okay, where the nature of the work is such that the person is not able to leave for that 30-minute period. Okay, if you're an in-home caregiver and you've got your disabled client that you're caring for, I can't say, okay, just sit there. I'm going to go have my meal break now. I hope you don't choke or keel over or whatever. Okay, that doesn't work. If you're a security guard, guess when all the break-ins would happen? During the 30-minute meal break when the security guard leaves. Okay, that doesn't work. All right, so if the nature of the job is such that the person is actually prevented from leaving, then that will qualify. Had a case not too long ago of a guy who had a bunch of, not like 7-Eleven, Mini-Mart, it wasn't 7-Eleven, but little convenience stores. Okay, and he said, well, the nature of the work was such that the person couldn't leave because I only had one cashier there. Well, that's your choice. If you're only going to have one person in the store, then he can either lock up the store and you can close for 30 minutes, okay, or you can bring somebody else in, you can rotate workers. Your economic cost, okay, isn't the thing that's going to be the necessity, the nature of the job. Yeah.
Yeah, and that would be my same question for the security guard. I mean, doesn't it depend on the size of the employer? Because essentially they can have another security guard.
You can have somebody come and relieve them, yeah.
The 30-minute period.
Yeah.
So where does it end?
The reason I use, well, and you are going to have to look at the size of the employer, where they are. If this is you're the security guard and you're way out in, Timbuktu, by the time you would actually, be able to leave and get from the security place to, home,
Almost like a reasonable
Yeah.
burden or.
Yeah. The labor commissioner uses that security guard one as the example. Although I have yet to see a case where it's actually a security company that says we've got all these 10 other security guards in reserve and we just choose not to bring them out there. A guy who's out on an oil rig, okay, on an offshore rig, all right? Well, you can't he can, you know, he can dive off and swim for 15 minutes, then turn around and swim back for 15 minutes. Then, you know, the nature of the work, he can't, you know, that's different because you're covered under a different wage order. But that's an idea where you just, there's no way to leave and there's no way to stop doing that job. Okay, very, very narrow and specific exception. What the labor commissioner says, if you fall into this category where the nature of the work is such that you can't have a meal break, you have an agreement signed in writing by both the employer and the employee. Says, I understand the nature of the work is such that I cannot take a meal break. Okay, you're going to pay them during that time. They're going to get paid for that 30 minutes where they eat on site. Okay, but they're not going to incur that penalty. That written statement also has to have a section in there that says, I, as the employee, have the ability to revoke this agreement at any time. Okay, it really doesn't make any sense that you have to have that in there, because if they revoke the agreement, it doesn't change the nature of the job. They can't then now, you know, but that's what labor commissioner says. You have to have that in the writing. If you're going to have an on-duty meal period agreement or waiver, make sure you've got that language in there. Okay, I get a lot of these questions. The labor commissioner really doesn't like those. If you walk in there and this is your defense was, oh no, on duty, you know, bring your checkbook or bring a whole bunch of documentation, because it's an uphill battle. Okay, so now we're going to talk about rest breaks, because we talk about meal breaks and rest breaks. The rest breaks are those little 10-minute periods that you have every, you know, for every 4-hour block of work. Okay, the Brinker decision that set the parameters for meal periods, where they said provide means provide an opportunity to take. Okay, they also looked at rest breaks. When are rest breaks actually due? And under that decision, we got this sort of breakdown of when the rest breaks are due. After 3.5 hours, they're due a 10-minute rest break. Okay, and that covers hours 0 to 4. Okay. After 6 hours, they get another 10 minutes, and that's for hours 4 to 8. After 10 hours, they get 10 minutes for hours 8 to 12, and so forth. Okay. You don't have to schedule that rest break directly at that exact hour, but that's the hour when their right to that break accrues. Okay. So at the 6th hour of work, they are now entitled to their second rest break. Okay. If they don't take it till the 7th hour, okay, so be it, if that's the way you've worked out your schedule. The key is they need to get within that 4-hour block of time a 10-minute break. Rest breaks are paid, okay? And so we don't mark them on the time card, okay? Meal breaks, even if the meal break is paid, you make sure it's marked on that time card, okay, so we can show that it was provided. The first rest break, typically they say it's for every 4-hour block or major fraction thereof is when the rest break right is going to get triggered. So major fraction thereof is anything more than half of that 4-hour break, except for the first one, which doesn't kick in until 3.5 hours. Okay. One of the things about rest breaks is, you know, I have yet to see the labor commissioner take a claim or issue any kind of judgment where the claim is just rest breaks. Okay, because it's very, very unlikely that your employee during the whole course of their day is not going to go to the bathroom, is not going to stop work, you know, for any block of time. Okay, so this is one where it's really hard typically for the employee to make that showing. If they couple that rest break violation with a meal break violation and they can show that, hey, there were no meal periods, you're much more likely to get hit with a rest break claim. But typically, you know, and if you've got somebody who smokes, generally smoking's not great for the employer, because guess what? Smokers, you know, get sick and they get emphysema and they run up your healthcare costs. Okay, but smokers are great if you're looking at a rest period claim, okay, because smokers take smoke breaks, all right, so they never prevail, pretty much. At any rate, those are the new rest break obligations after Brinker. Okay, I'm skipping over this exemption because that was not supposed to be, we'll hit exemptions later on. Okay, special issues. These are some of the special things we're going to talk about: on-call and standby time, reporting time pay, travel time, training time, PTO, vacation and floating holidays, and piece rate workers. These are sort of, when we talk, we're still in that hours section. What time actually needs to be paid? But these are sort of special issues that come up for different employers. Okay, so on-call and standby time. I get this question a lot. Hey, I send my guys out, they have to keep their cell phone with them. Do I have to pay them now? You know, well, I don't know, maybe. You know, Do you have any restrictions on when they have to report back? How soon they have to call in if they get a call? You know, are they allowed to drink? Can they go to the movies? Whatever. Depends on how much restriction you put on that employee. Okay, if they just have to carry their cell phone, and if something happens, they have to return the call within an hour, and then they may have to show up if that's the case. But other than that, they can do whatever they want, then that's probably, you probably don't need to compensate them for that. Okay, if this is somebody who's got to wear their pager, and when the hospital dings, I've got to be at the hospital in 20 minutes because I got to be ready to go to surgery, so I can't drink, and I have to, you know, keep my geographic distance from my work site limited to somewhere I can get back in 20 minutes. Okay, those are pretty restrictive requirements. Chances are that time is going to need to be paid. Okay, so that's what you want to look at. If they do get called back to work, you know, they answer the phone, hey, the place is on fire, come down here and help us, or whatever. Okay, and they drive to work, travel time from that point when they're called to getting into work needs to be compensated. Okay, generally when you've got somebody who's traveling to work, the start of the day, start of a shift, that time is not going to be compensated, that travel time from their home location to the office. In this case, they're coming from their home to the office, but it's because they're getting called back in. That travel time does need to get paid. Do you have a question, Bill?
Yeah, what if that doesn't require an actual movement from point A to point B to answer questions that you still have an on-call necessity?
Yeah.
Is there a minimum hours paid that would have to be?
No, so you have somebody and they keep their phone, and I'm not paying them for they just have a phone. Okay, somebody needs to know where the key is to unlock the garage to unload the truck. Okay, and I tell them it's in the file room. Okay, it takes 2 minutes, 3 minutes. That's hours worked. That's time that I've worked, so I record that on my timesheet and come in and say, by the way, I took 3 calls for a total of 7 minutes. Okay, that's something that needs to go on the timesheet. I don't get paid for any of the travel time. I don't get paid for anything else. I'm not getting standby. I'm not getting on-call pay for my time when I'm on call. But so I'd only get paid for the actual time that I work. Okay. If you have somebody that you pay to be on standby, and I'm paying you $10 an hour so that you can answer a call if it comes in the middle of the night, the call comes in the middle of the night, you're already being paid for that time. So I don't owe an additional payment for the time you spend taking the call. Okay, but if you take the call and then you get in your car and drive there, now I need to pay you for that travel time. Okay, in addition to your typical standby time. Okay, are there questions? All right. Reporting time. Okay, so there's no reporting time pay under federal law. Okay, but of course we're in the giant oleander tree of California, so we have all these reporting time obligations. There are 2 times when reporting time pay is going to get triggered. Okay, the first one is if they show up for work. Okay, this is the employer was irresponsible. They schedule somebody, the person shows up for work, and guess what? There's no work to do. Okay, so you send them home, or there's some work to do, but it's like an hour's worth of work, or it's less than half of what you were scheduled to work. Okay, if the person shows up and they either don't work at all, or they work less than half of the regularly scheduled shift, okay, then they have to be paid a minimum of 2 hours up to a maximum of 4 hours of pay for that day. Okay, that's for the irresponsible employer who doesn't manage their workload. Okay, and there's some exceptions to that we'll go through. All right. The other time that reporting time pay gets triggered is if somebody gets called in and it's an unscheduled workday. Okay, it's Saturday. Hey, you need to come in. Everything blew up. Okay, and they have to come to work. They need to be paid a minimum of 2 hours of work. Okay, the key word there is unscheduled. If I have my guys and they work all week long, and now I want to have a safety meeting, and I'm going to bring everybody in for the safety meeting on Saturday. Okay, nobody typically works on Saturday. This is an unscheduled day. If I schedule that meeting in advance, okay, and I tell them to come in, you're going to come in for a 1-hour safety meeting, okay, we're not under the reporting time requirements because now that Saturday has become a regularly scheduled day, okay, and they come to the meeting. Now, a lot of clients that if they're bringing them in on an unscheduled day, they'd always pay that 2 hours. But as long as you schedule that meeting in advance, you're going to get out of the reporting time pay. The little sort of twist on that, if you schedule everybody for a 1-hour meeting, we scheduled it in advance, okay, so now they're going to come in, they're going to get paid for that 1-hour meeting, and then I have a speed talker who does the meeting, and the meeting finishes in 29 minutes. I've all of a sudden had somebody come in, work less than half of the scheduled shift, So now I need to pay them 2 hours of pay, even though they came to the scheduled meeting and only worked for 29 minutes. Okay? So if you schedule somebody to come in on one of those off things, just be careful. Make sure you fill up that hour or whatever you've scheduled them for. Okay? Don't let it fall below that 50% mark, because that's where you can backdoor yourself into a problem. Okay.
And that time's to be used for calculating overtime. Any of the additional time that we paid them that they didn't work or were at the meeting.
Yeah.
Needs to be used for the purposes.
Of overtime, yeah. No, reporting time pay doesn't get factored in. Those additional 2 hours, unless they were actually working. If they were actually working.
We would have them separated. So
Yeah.
if they were there an hour, but we paid them 3.
Yeah.
We would do it separate.
Yeah.
So those additional 3
Doesn't have to be used, as long as they were for the time that they were actually working. That's what we care about for overtime. But yeah, if you pay them a penalty or whatever, I have a lot of people that say we'll pay you 4 hours for the first call, or 2 hours for the first call in, 4 hours for the second call in, whatever, if you have to come back in, even though they might only work 30 minutes, and so that additional 3.5 hours of pay is not for hours worked.
It's good to separate
Yeah.
it though to show
Yeah.
how you're.
Well, so you can see the calculation in there, so you can see that the reporting time is paid, yeah. Okay, the exceptions. The exceptions, when I talk about the exceptions for when the scheduled day, where the employee comes to work and guess what, we can't work. Okay, the exceptions of when you don't have to pay those minimums of either 2 hours or a maximum of 4 hours. Okay, as if you can't do operations, there's some threat. Okay, there's a bomb threat, or it's whatever. If public utilities are all down, okay, or a state of emergency is declared, something like that. If there is what they call an act of God beyond the employer's control. Where this comes up for a lot of my clients is when you've got rain. I got a bunch of ag guys out there, they can't work in the rain, we're going to get struck by lightning. This isn't safe, okay? What you need to look at is if the forecast is a downpour and it's raining outside and you still schedule everybody to come in and they show up and you say, oh shucks, it's still raining, okay, go home. Well, that's within the employer's control, at least in terms of foreseeing that. If everybody shows up to work and, oh my God, there's this sudden, summer squall and it's pouring rain out of nowhere, that would be an act of God. Okay, but the weather's a little bit tricky. That's something you really need to manage. If you've got people that are working outdoors, or if that's something that's going to really halt your operations, you want to stay on top of that. Okay. Somebody who's on paid standby, okay, who gets called back into work, again, you don't need to pay that reporting time, that additional breakdown. If you're already paying them to be on standby to work, you're paying them for that. Okay. Where this comes up for employers, where it creates problems, I'm going to pay you your on-call rate of, whatever, $10 an hour. Okay. But when you come to work and get called in, you're my welder and you make, $40 an hour. Okay. So if you've got somebody, when they come in, they then start doing their actual job, they're going to kick into that higher rate. So you need to make sure that we balance those, do that weighted blended average if we need to do overtime and so forth. Okay, so that's something you're going to want to watch for. All right, travel time. Employee is entitled to compensation beginning when they reach their first place at which his or her presence is required by the employer. So if we have that mandatory, bus that takes everybody to the lease, all right, once they get to the place where the employer is telling them they need to be there, that's when the day starts, that's when travel time kicks in. Okay, for time spent subject to the control of the employer, whether or not they're engaged in physical or mental labor. Okay, when you're under the control of the employer, when they have you in the place where they told you to be, okay, even if you're sleeping, all right? And for all times during what, that's the same thing, suffered or permitted to work. Okay, varying rates for travel. You can have a travel rate. Okay, great, while you're traveling, you're making $10 an hour. You're making whatever, okay? Make sure though that, you understand that when you use the multiple pay rates, that's going to create additional burdens in terms of your overtime, calculating that weighted average, trying to figure out how much the person makes. If you've got somebody who's making multiple pay rates, make sure that we don't only pay overtime at that lower travel rate. Okay, that's typically what happens, because the travel home, okay, is the time when they're often in the overtime hours. Okay, and so the idea is we want to pay overtime based on that travel rate. That's not okay. All right, you're going to need to use what they call the weighted average, and we'll get to that when we talk about overtime. Okay. New job locations, the delta between the normal commute and the travel to the new location. This is the area where I told you labor commissioners just made up whatever they want. Okay, there's nothing in the labor code that says when that employee is working really far from where they normally do, you have to pay for that. Okay, but what the labor commissioner says, if you have an employee who typically, you know, lives in Bakersfield, works in Bakersfield, and you say, I'm sending you to Fresno now, and you're going to work out of the Fresno office, and now they have to drive from their house to Fresno every day. Okay, what the labor commissioner will tell you is anything beyond what they typically normally would have done is what you need to compensate. So they were driving 15 minutes before, and now they're driving an hour and 15 minutes. Well, they're going to be entitled to compensation for that additional hour. Okay, the delta, the difference, that's what that means. The difference between the normal commute and what they're now being expected to do. Okay, but again, this is, so if you get a travel time claim, that's what the labor commissioner is going to tell you you need to pay. Okay, if you want to then hire lawyers and fight it in Superior Court, you might win. Nobody has fought that one yet. It's a lot easier and cheaper just to pay the travel time pay, which is probably why, but yeah.
Now, do you have employees that go from home to the well site versus employees that go from the company's place to the well site? The guy that's coming from the company is going to get the travel time.
Yes.
The guy that's coming from home going to the same well is not?
Yes.
Is that fair?
Yes. Well,
Is
if,
it fair?
what does fairness have to do with anything? Like what? Truth, justice, fairness?
I complain
Yeah.
because our customers bill us for travel time. They pay us for travel time.
Yeah.
So, and if we send them straight from home to work in the company truck, they get to take the company truck home. Is
Uh-huh.
it fair for this guy to get 12 hours of work when the other guy is getting 14 hours of work?
Yeah. I don't know anything about fairness, but I'll tell you that's what the law says. If I'm the employer and I say you need to report to the office and then you go out to the site, you report to the office and and don't even do anything. I don't just show up here so I can see your smiling face and now go out to the job site. From the minute that after they've reported to that job or the office, all that travel time is going to be paid. So versus the guy where I say you get out to the lease site. Don't come to the office first, just go out there.
Even if he's in a company truck?
If they're providing him with a company truck, that's a nice thing that they're doing, That may create liability if there were an accident or something along those lines, but yeah.
Or sometimes they have to do pre and trip inspections and they have to do something to the truck at
Yeah,
home
yeah.
before, just in my experience.
Yeah. Well, and that's, if you're bringing the truck to haul the tools and equipment or something, if you're doing something, even though you're coming from your home, but you're doing something the employer gets a benefit from, then that might create an obligation to pay for that time.
And is GPS
If-
modified? Is GPS and everything doesn't matter?
No, GPS doesn't. That's just so they can track where their truck is going or not going. But if, a lot of times the employer will say, hey, we'll let you use the truck and you don't have to come, you can take it home, whatever. Okay, because it's a lot cheaper for them. Because if they require you to take that truck back and lock it up, put it on their site so they know it's safe and it's all washed and that creates more pay for them. Obligations in terms. If they tell you, you go ahead and take it home, whatever, then your day ends when you leave and you get in that truck and you're free to go wherever you want, So, yeah. Is it fair? Yeah, I don't know. Yeah, but that's what the law says. So, and you'll find that where, you'll find that where the employer will have, the one guy has to stop at the office to get all the ice and get all the water, or get all the other stuff ready so they can go out to the field and meet everybody else. Okay, that guy is going to get paid, but everybody else, I want them to just arrive at the site. Yeah, in the back.
And so when they leave then with their time, if they went from the job site straight home, would then get their time in when they got home or in when they got in the truck on the job site?
It would end at the job site unless they're also driving some equipment back for the employer or doing something else to benefit the employer. But typically, I'm going to let you use my company car. Okay, you use it. When you show up at work, you start getting paid. And when you leave work, you stop getting paid. Okay, because you get in that car and you can go to, the foot massage place. You can go do whatever you want to do. Your job ends at that point.
But if they went to different job locations on different days, it's not the same place each day, is that still applicable?
Well, yeah, and that's when you need, it depends on how far apart, if one day you drive for 15 minutes to work and then the next day you drive 20 minutes to work and then the third day you drive 4 hours to work, well, there's a huge difference. You're probably going to run into that problem where the labor commissioner says they get the difference between their typical commute, you know. But if the commute times are within 5, 10, 15 minutes of each other, I would say that's probably fine.
So what would be reasonable?
What's reasonable? I mean, if I knew the answer to that, I would patent it and then I would move away. Yeah, yeah. It's whatever the labor commissioner says is reasonable.
Well, and like you said too about the truck, you know, you said, oh, you could stop here, you could stop there. Well, a lot of companies have policies that prevent you from using the company vehicle for personal reasons.
Yes.
So I think it's important too to look at those restrictions too. before
Yeah.
making those comments.
Well, and you raise a good point, because you've got somebody in that company car. We had 2 really interesting cases that totally conflicted with each other last year, and one was a girl who was using her own car, okay, and the employer said, you know, go to Kinko's and pick up a new toner for us, and then and he didn't do this every day, but on occasion she was asked to use her own car for company purposes, you know, pick up the donuts for the lunch thing or the whatever. Okay, so she's running errands periodically. Okay, she drives her car home. She actually was driving to a yoga class, runs over a guy on a motorcycle, horrible accident, whatever. Okay, and the court said the employer is that's gonna fall under, you know, the course and scope of employment, because the employer got a benefit from that personal vehicle that she was using. Okay, and this fell under their, you know, workers' comp and all their stuff. Okay, everybody sort of went, what? It's her own car, it's after work, she's going to a yoga class, but that's what the court said.
What case was that?
No, I'll look at it, I don't remember, I'll look it up, yeah, it was, so there was that one, and then on the flip side, there was a guy who had a company car, okay, and the policy, don't drive this for anything, only the employee can drive it, you have to have a valid license and insurance and blah, 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 our fancy language we put in every handbook, okay, and he actually drove, he was, I think, in like somewhere down south, so Seal Beach or somewhere, and drove to Bakersfield to meet his wife because they were going to buy a new car. And they drive to the Bakersfield lot and they don't buy the car, and they leave, and then he gets in this horrible accident on the Grapevine. He's in a company car, and the court said that was not within the course and scope of his employment, because he was far enough away from his location. The employer had said, you're not allowed to, you know, you could use this to commute to and from work, but you don't get to, you know, go on a road trip in our work truck, okay? And so that was enough to take that out, okay? So if you allow somebody to use that company car, all right, make sure you have those restrictions in, okay? All right, whether you're not going to be on the hook for what exactly happens in that car, you know, when they run over someone or drive drunk or whatever they do, you know, that's a separate question in terms of whether or not they're going to be paid for every minute they're driving that car. Okay? Yeah, Lauren.
Just along the same lines, if someone's on a break and they're using their personal car and they get into an accident, is the employer necessarily liable because they're on paid break time, or is it?
Well, typically, if it's a rest break, okay, you generally don't leave the premises. You know, it's 10 minutes, you know, whatever. That's not typically something. If this is a break, because I told you, oh, you're due for your break, hey, while you're out there, will you grab something, you know, go, if you're doing an errand for the employer, then that's something that's going to be covered, okay? If this is totally off-duty time and no one's asked you to do anything, it's going to turn on whether or not the employer gets a benefit from you bringing that vehicle to work, which was the case of the girl doing the yoga class. Okay, if you're the employee that I ask all the time to run and do the errands, and you ride in your own car, okay, the employer's getting a benefit out of that, that may get covered. Okay, so, you know, be careful. Be careful who you ask to, you know, do those errands for you. All right, and you know, typically it's the young person in the office. Okay, so guess what they're doing in addition to doing your errands? They're texting all their friends and they're, you know, whatever. So that's where, you know, this is not, have the you know, old person who drives real slow, the safe driver, whatever, the non-alcoholic do the errands for the office. Okay, that's my advice. Yeah.
So another question, on Fridays, you have a group of ladies that all choose to eat lunch together, one person chooses, and they go and get lunch for everyone. It's for the group setting, would that fall under that? I mean,
Is this for people streaming? And for the question is, if I've got 4 employees and one every Friday goes out and picks up the lunch for everybody else, is this something that the company is sponsoring, or these are just 4 coworkers that all like to just eat together?
Right.
And this is separate, and this is on them, and they've decided to do that? Probably not. You know, I think that's would probably fall outside. I mean, they're free to do whatever they want for lunch. If they want to sit there and wait while someone delivers, and if somebody else wants to get in their car and go get it and deliver it, then that's on them. As long as it's not. Where you run into problems is if it's 4 workers and it's the 3 workers and the supervisor. And the supervisor says, oh, this is so fun, we'll all get together for lunch. Well, those 3 workers can pretty easily come back and say, well, she's my boss, she told me to do this, I felt like I had to. You know, if it's 4 that are peers, there you don't have that supervisory role, you're a lot less likely to run into that problem. So, actually, it's 10:30. Maybe we'll take a quick 10-minute break. Are there any more travel times? Yeah, well, and then we'll come back and bump into the training time. All this fun stuff. Thank you. Okay, I think we'll get started again. Okay. All right, I think we're all back. Okay, so I'm gonna get started again. Is temperature okay over here? Are you guys hot? Cold? Okay. Oh, you were cold, you turned it down? Okay. Yeah, it feels like it's gotten warmer. Yeah. Sure.
On the, meal and rest breaks,
Yeah.
you have on here that the duty-free 30-minute meal break, you said occur before the end of the 5th hour.
Yes.
And so what does that mean? Because we've been operating under the assumption that it has to be taken by the 5th hour.
Yeah. Started. Started or finished?
Right, it has to be started by the 5th hour, so before, if they work, start at 8 o'clock, they must be relieved by 1.
Okay. Well, it needs to be completed before the end of that 5th hour. Okay. So, yeah, that's what the.
Leave at 1, come back at 2.
Yeah.
5 hours.
1, 2, 3. Yeah. So, what time did you say it started?
If they start at 8, the 5th hour would.
9, 10, 11, 12, 1.
Take a meal break at 5, 1 o'clock.
They have to start that meal break. Yeah.
Okay.
Start it. Yes. Started. Finished by before the end of that 5th hour. Okay. Were there other?
You said finished?
By the
I
end.
heard completed and I heard finished.
Yes.
So if they start their shift at 5, they would have to take their
Finished by the end of the 5th hour. So,
by 10,
yeah.
so they had to start it at 9:30,
what time do they start?
5 in the morning.
6, 7, 8, 9, 10. They have to start it by 10.
Oh, start it, but it
Yes.
doesn't have to have been completed, because you said finished and completed.
No, not by the beginning of the 5th hour.
Okay,
Yeah.
just take it, it needs
Yeah.
to start prior.
Prior,
10,
yes.
Before 10.
Yes. Yes.
10.
Yeah. Exactly. Yeah. 10.001 or whatever it is. Yeah.
Okay.
Yeah. Okay. Are there other? That's how technical this stuff. It gets down to the second of the start of the meal period. Okay. So we talked about this. I think had we finished travel time. Were there other questions about travel? Okay. Let's get into training. Okay. If the employer will benefit from the training, generally the time is going to be compensable. Okay, when they send you, when your employer says, hey, come to this wage and hour seminar, they don't get to say, lucky you gained all this great knowledge and got to see this fabulous speaker, so we're not going to pay you. Okay, that's training that's time you need to be paid for. Okay, if it's a safety meeting, all that kind of stuff. You know, even if you say, hey, this is this voluntary meeting, anybody who wants to come to this special voluntary meeting we're having, okay, 9 times out of 10, that employee can come back and say, well, I felt like I had to go because the supervisor told me to go. Okay, this was a meeting that related directly to what I was doing. They got a benefit out of me being trained. Okay, so probably that time is going to need to be paid. You can pay it at a lower rate. If I'm paying somebody to go to training and they typically make, $50 an hour, I don't have to pay them $50 an hour to sit in a classroom. All right, but I do need to probably pay them for that time if I'm telling them that they need to go to that training. Okay. The ways to get out of having to pay are if you meet all of these factors. You have to meet every single one of them. Okay. So the attendance is outside of their normal working hours. It's voluntary. And again, it's easy for an employee to one day say something's voluntary and then come back after the fact and say, well, it wasn't really voluntary. There was a tacit understanding that anybody who didn't go to the training was not going to be up for the promotion or wasn't going to get the same treatment, whatever. So it has to be truly voluntary. It's not directly related to their job. Okay, so this is a training on photo taking or something, whatever. The employee does not perform any productive work, okay, during that training. We talked a little bit earlier, I think, about that trainee or learner rate. First 160 hours can be paid at a sub-minimum wage rate. Okay, this is if it's something that the person's never done before. That's fine and good, and you can save some money on this trainer rate. It's really, as a practical matter, hard to track, you know, making sure that right when they bump over that 160-hour mark, you catch it, and then they bump up to the regular rate. I think it's more trouble than it's worth, but it's certainly out there as an option, as a cost saver. Questions? Training? Yeah.
If you are out in the training and you're being paid, let's say you're out at Air Energy and they have a big walk or whatever, and they provide you lunch.
Yeah.
Maybe you don't take it all the time because you weren't really providing lunch. You were providing lunch, but you had to stay right there.
Yeah.
And it happened on numerous occasions. They weren't allowed to take their lunch.
Well, and you raise a great point. So I'm going to have we're going to work, and then we're having a lunch meeting, okay? And everybody's going to come in, and it's, you know, whatever, the safety guy or whatever. We're bringing in lunch for everybody. We're all going to sit here and go to the meeting, okay? The time when we're in that meeting, the employer's requiring me to be there. I don't care whether they're giving me a sandwich or a steak or a lobster or whatever. They're requiring that I be there, so that time is paid. Because they're requiring me to be there, I'm being deprived of my opportunity to take my lunch when I normally would, where I could leave duty-free, 30 minutes, uninterrupted, all that stuff. So I'm now entitled, in addition to the lunch they're giving me, in addition to the pay for the time that I work, to that 1 hour missed meal penalty, okay? So when you schedule that lunch period, that's something that's gonna need to be paid, yeah. You don't get to offset the wage obligations with food, is what it comes down to. And I see that a lot, where they say, well, you know, that was Chipotle's argument. They're like, we paid them for their meal period, and we gave them nachos or whatever. Okay, give me a break. And then they came back and ended up having to shell out a whole bunch of money because none of those meal periods were recorded. It didn't matter that they would provided a lunch and it was catered and whatever. Okay, if you have a catered lunch and it's lunchtime, we're going to celebrate the August birthdays, and they bring in a bunch of food, and we do that once a month, and that's voluntary, and you can come to the potluck lunch or not. Well, that's something different. I don't have to pay anybody who chooses to come and eat our cake or whatever. But if this is something I'm telling the employees, you've got to be out, we're going to have to do this at lunch, then we got to be there. Is there a question? No? Oh, I thought there was a hand maybe back there. Okay. I've started seeing things. Other questions with the trainings? Okay. All right, PTO, vacation, and floating holidays. And again, we're still in that hours section. We talk about wage and hour labor. We're still looking at what time do we have to compensate people for, okay? You have no obligation to give people time off. Paid time off, vacation, sick leave, holidays, floating holidays. You don't have to do any of that. You can opt to never give anybody any kind of paid leave. There's one exception to that. There is an organ and donor, or bone marrow donor law that requires employers to provide paid leave if somebody's going to give up an organ or they're going to give up their bone marrow, okay? It's not really one that the employees can like game the system that much. So I don't know if anybody's willing to give up, you know, a kidney in order to get, you know, 30 days off. But anyway, that's the one instance where private employers are obligated to provide paid leave to their employees. Okay, I think we're in the slippery slope. We're eventually going to get to that place where there is mandated and required paid sick leave at least. I think the very first step was that organ thing, and you'll start to see new legislation coming down the pike. I just think that's where the push is. But for now, no obligation to pay for holidays, for any of that kind of stuff. Okay, if you do provide those leave rights, paid leave, whether it's called PTO, whether it's vacation, however you set that program up, there are certain obligations that are going to be triggered. Okay, if you decide we are going to give everybody sick leave, well, okay, that all of a sudden triggers what we've called the kin care statute. You have to allow them to use half of that sick leave in order to care for their family members who are sick. So when the employee calls in and says, I feel great, okay, but my kid is sick, we have to allow them to use that sick day, even though they're not actually sick. Okay, so there are some of these other regulations that get triggered if you choose to offer that. So the big debate, and the question I always get is, should we just have PTO? Or should we have vacation and then sick leave? Okay, the downside to providing vacation and sick leave as two separate pieces is that if you give somebody, you know, 5 sick days a year, guess how many days they're going to be sick? Okay, they're going to be sick 5 days, okay, at a bare minimum. All right, so that was the downside. A lot of employers where if they really are pushing to make sure the employee shows up, and that's really critical, then you may not want to actually have a sick leave bank, because you encourage people to call in sick. Instead, you might want to have just PTO. You get a set number of days off. You can use them if you're sick, if your kid's sick, if it's your vacation, whatever. Set number of days. People are less likely to call in sick. The downside to PTO is that all PTO, if you package it like that, is going to be considered deferred wages. And what I mean by deferred wages, this is time, if it's unused in their bank, the time that they quit or are fired, we've got to pay all that out. Okay, sick leave, if it's in the bank, I was fired, I had 5 sick days on the books, I don't get paid for those. Those are not considered deferred wages. Okay, so there's a pro and con to each side. Vacation wages, okay, they're just like PTO. Those are considered deferred wages. The time and place of termination, okay, or within 72 hours if they resign, you have to pay for all of that accrued, unused vacation. Okay, holidays are a little different. Typically, holidays are not going to be considered deferred wages. Okay, we're 4th of July. We pay everybody for 4th of July. We're not open, whatever. Okay, if I quit on July 3rd, I don't get payment also for July 4th because it hasn't happened yet. Okay, that's not considered an accrued wage to me. If you have floating holidays though, okay, hey, you get 3 floating holidays, you can use them throughout the year. Well, that's going to be considered vacation. That again would be considered deferred wages. If it's not anchored to a specific date, okay, if it's just a day that floats around, you can take whenever. All right, if it's anchored to, hey, you get your anniversary at the firm off, okay, that's anchored to a specific date. That's not going to be deferred. You get your birthday off, something like that. Okay, you can take any day within your birthday week off. Okay, something along those lines. That's not going to be considered deferred wages probably. But if it's a free-for-all, open, whatever, you can, it will probably be considered deferred wages. Okay, time must be paid according to the employer plan. One of the key things with, to remember with vacation, PTO, sick leave, all that kind of stuff, this is where it's really helpful to have that introductory period. Okay, typically, you know, when we talk about a probationary period, an introductory period, it doesn't really change your rights or your obligations too much from the employment standpoint. That person's protected whether it's their first hour, you know, in terms of harassment, discrimination, all that kind of stuff, workers' comp, you know, a lot of the leaves, pregnancy leave, a lot of that stuff from the minute they walk through the door. But you can use that introductory period at least to limit vacation and accrual and sick leave accrual, all that kind of stuff. So you don't start accruing your vacation until you've completed that introductory period. Okay, if you structure it that way, then when they don't work out, it's been 2 months and we terminate them, I don't need to pay them for anything that's on the books because they don't have anything on the books because they have not started accruing it yet. Okay, if you don't have that in place, hey, everybody accrues, you know, a week of vacation over the course of the year. They're going to go parse that out. How much do they earn, you know, each day? This is how many days they worked. That's how much additional wages you're going to owe in terms of vacation wages or PTO. Okay. So it's worth having that introductory period that specifically carves out that you do not accrue during that time. Yeah, Lauren.
So if you have that introductory period, you can't take PTO for the first 90 days, and you start accruing it from day 1, you still have to pay it out even then.
Yeah, the question is if your policy is you start accruing from day 1, but we're not going to allow anybody to take any paid leave during that first, you know, 90 days or what, 180 days, whatever you want to put. Okay. Yeah, they're accruing from day 1. So, you know, they get fired, and guess what? I couldn't take any of this time, but it's all still accruing on the books. If you're going to bother having an introductory period, you're going to bother limiting when they can take the time, I would say just don't let them accrue from that start date until they finish that introductory period. Okay? Because that's the time when you're going to find out, like, are they a good worker? Do we want them to be accruing this time? Okay, so that's all stuff that needs to get paid also. Piece rate workers, and we'll kind of talk about this again when we get those strategic compensation structures. But when we talk about hours work and time that specifically must be paid, we had a big change with respect to piece rate workers this year from the courts. I can't remember the name of the case, but I could get it for you. Basically, piece rate workers are people that are paid, you know, per widget they create, okay, or per job, or they're paid for a specific thing. I'll give you $10 for each widget you make. Okay, great. We have a lot of mechanics that are on this kind of thing. Sometimes it's called a flag rate. You know, you're going to do a brake job. Okay, I'll give you, you know, X hours of pay for one brake job, regardless of how many hours it takes you to do it. Okay, and this has been a pattern practice. It's been fine, sort of blessed by the labor commissioner, and everybody's rolling along just fine. Now we have this lawsuit, and the lawsuit said, if I'm a piece rate worker, okay, and I'm on the assembly line doing my piece rate working, and that's how I'm making my money, but you know, the conveyor belt breaks, and now I don't have the opportunity to make any more widgets, okay, because nothing's coming through. or I'm a mechanic and I'm there to do brake jobs, but there's no car for me to do a brake job on, okay, so I just have this downtime, I'm not being compensated for that time when I'm there, okay, because I only get paid for each piece I produce, each brake job I do, each widget that comes out. So if I'm there and there's downtime where I cannot work on additional pieces, that's time that's not being compensated. And the court said, that's right, you don't get to have that. Any downtime they need to be compensated for, okay? Other downtime that happens for piece rate workers are the rest periods. Remember, the rest periods have to be paid, okay, but they're allowed to stop working. During that time when they stop working, if they're only paid on a piece rate basis, they're not being paid for those 10 minutes during the course of the day. Okay, so if you've got piece rate workers, you want to make sure that we factor in, you know, an additional hour of of minimum wage or something that will pick up that time. If there's any downtime, we can, you know, have them note that on their time card. You know, the easiest way to fix this problem is to pay everybody at minimum wage, okay, and then have a piece rate incentive or a bonus program or something that would encourage them still to, you know, make a lot of pieces during their time, but that covers you from that angle. Okay, this is a big change. It's a very different way from how things had been done previous to this. Includes downtime. Okay, so we covered all that, mechanics and flag rate. All right, time cards and time sheets. So this is where we get to, how do we know what the hours are? We talked about, in theory, which hours need to go on that time card and need to be captured, okay, but how do we actually get that information from the employee? And the key is this information needs to come from the employee, okay? If it comes from the supervisor, okay, the employee can come back and say that was wrong. If you're in a situation where the supervisor fills out these time cards, we at least want to give them back to the employee so that they can approve it, authorize it, sign off on it, you know, verify that this is accurate. I want that employee to have an opportunity to make changes, corrections, to initial that they will tell you if there was any meal period they were not allowed to take, all that kind of stuff, okay? Because when you walk into the Labor Commissioner's office with all of your nifty timesheets that are filled out by the supervisor, okay, it's the same as almost not having time records if that employee never validated any of that, okay? So they're entitled to compensation for a time when they're subject to the control of the employer, okay? The accuracy tends to be a big one, all right, where they didn't get filled out all the way, they're incomplete, you can't read it, okay, all this kind of stuff. The supervisor did it. When you have those issues, okay, the timesheet's all jacked up, that's a performance issue. They need to complete that timesheet, okay? It's a performance issue for the supervisor who's not getting it to them so they can sign off. It's a performance issue to that employee who's not filling it in, they're not filling it in correctly, they're not turning it in time, okay? Regardless of what the problem is, we're still going to pay that employee. Okay, if they never turn in the timesheet and I'm trying to cut the payroll, this is a question I always get. Well, how do I know what to pay them for? You know, I don't have their timesheet. I don't know when they worked. Okay, we can't withhold wages, but what do? Typically in that situation, you want to pay them for the hours either that you knew that they worked. If you happen to know what hours they were working, because the supervisor knows, you pay them for those hours. Okay, if you don't know what hours they worked, you can pay them based on the hours they were scheduled. Okay, it's probably a safe bet. And let them know you need to contact us so that we can make any adjustments to this, okay? If there's unpaid overtime, the unpaid overtime piece you can at least delay till the following pay period. But those straight time wages, you don't get to delay even if they never submit any time sheet at all, okay? We still need to pay that straight time wages. And the reason it's so important to pay that is because if you don't, now all of a sudden you trigger those waiting time penalties that we talked about, Labor Code Section 203, okay, where we get into that 30 days of pay, okay? So you don't pay the straight time wages, and then we get mad at them for not turning in the time card, then they wait, you know, the 31st working day and come back and get mad at you. Now, in addition to the wages that you owed, you also owe an additional day of pay at their regular rate, okay, for each one of those days that they had to wait for those wages. Not worth it. When we get those DLSE claims, you know, it'll be, you know, I missed these 5 meal periods and these 5 rest periods, and I want, you know, $8,000 in penalties. You know, I'm not kidding. That's really the way it goes. The actual damages, you know, at the regular rate of pay, you know, will be $140 or something, you know, and then the penalties are just huge. So that's what you want to watch for. So Make sure, okay, they have to be in ink. You can't fill them out in pencil so they can get changed. You don't have to have time clocks. Okay, a lot of people are going to the little like smartphone, like an app, okay, where I click on it, you know, log in, and then when I'm done with my shift, I log out. Okay, that's fine and good, but if the person is on their smartphone doing stuff like that, if they log out and then do other stuff, make sure they're informed and know that they need to go back and recapture that time or have some way to pick up time that falls outside the parameters of when they've clocked in and out like that, okay? It's the same if you've got non-exempt people who are taking devices home, laptops, all that kind of stuff. Make sure they understand you're not to work during your off-duty time. If you do, you absolutely need to write this stuff down, okay? If they get called back in on a, you know, on call or standby, make sure they know to designate that on the timesheet. We need to keep those time records for 3 years, okay? So when you walk into the Labor Commissioner, oh shucks, we don't have that anymore. You know, we would have been able to refute everything, but we don't have it, okay? You're gonna be in trouble for that. So that's not a defense. Meal periods, the beginning and end of the lunch must be recorded. I sort of hammered on that one, I think. You can't rely on posted work schedules. That's not the same as having a time card, even if you have the employee initial that work schedule. Okay, they want to see the actual times. And this is the thing that I run into all the time. Here's our printout. Yes, we absolutely have all the time recorded. And you look, and every single employee starts at 8, 8, 8, 8, 8, 8, 8. Okay, and they go to lunch at 12, 12, 12, 12, 12, 12, 12. They come back from lunch at 12:30, 12:30, all the way down, and then they leave at 5, 5, 5, 5, 5. Okay, that is not an accurate record of their time. Okay, that's their schedule. There is no way that every single employee arrived at work at exactly 8 on the dot and left for lunch at exactly 12 and came back from lunch at 12:30 exactly, whatever, 5. Okay, there's no way that happened. So you want accurate, you know, it should say 8:01 and 7:52 and 8:15 and 8:04 and 8 o'clock and whatever. You need to show accurate time records. Okay, the Labor Commission will throw those timesheets out unless there's some way you can show we had an alarm that sounded and that's when everyone started or something. Okay, but it's very, very difficult to show that those time sheets are accurate if they show an identical time for everybody. All right, a lot of this comes down to an educational issue too, because your employees a lot of times aren't writing that exact accurate time because they don't want to get in trouble. They don't want to get in trouble for, you know, I showed up 10 minutes early and now I'm going to have some unauthorized overtime, or I got here 5 minutes late, so we'll just go ahead and, you know, pretend I got here at 8. Okay, so as long as they understand, we want the accurate records. Okay, not everybody can get there at exactly 8 on the dot. That's fine. And you can round. Rounding in 5, 10-minute increments is fine. I think under federal law you can even round in 15-minute increments. But, you know, that's fine. You know, we'll round. The key with rounding, you can't, you know, we round up in the morning and down in the evening or whatever. You can't only round to the detriment of the employee. You either, you know, you round based on whatever the numbers are. So at some point, there may be 10 minutes of overtime that the employer gets hit with. Some point, there may be that the employee, you know, works less. But we can't always round to the detriment of the employee. At any rate, if the employee understands this is part of their job, you got to write the accurate time, you got to write the accurate time, and that's it. Okay. Okay, erroneous time clock punches. Minor discrepancies can be disregarded if they didn't work, but get a written statement from the employee. Okay, if their time thing is way, way off, you want to make sure you get an acknowledgement from them. Okay, hey, I forgot to clock in last night or clock out. So obviously you didn't work 24 hours. Okay, you sign off that I forgot to clock out, and they sign, and that's fine. We don't need to pay for that just because it's on that timesheet if it's obvious. Okay, but it's always better to have the employee acknowledge that, you know, because they might forget that they forgot to clock out, you know, when they're really mad at you after you fire them. Rounding practices are okay, 5, 10, 15 minutes, and that's what I just say. Rounding can't result in failure to pay the employee. There's this thing called de minimis time, okay, and the idea is you can deduct or not pay for what's called de minimis time, and that's time that's too difficult, it's just not practical to capture from a payroll standpoint. Okay, but what they mean by de minimis time, because I'll get this, you know, well, that's 5 minutes. That should be, you know, that shouldn't count. Can't we just get rid of that minimum time or whatever it's called? Okay, what they mean by de minimis time is 1 second, 2 second, 5 seconds. Okay, it's the employees walking across the parking lot where they say, hey, did the fax come through? And you say, yeah, I saw it, it's on the machine. Okay, I don't have to run back in now and say, well, 0.04 tenths of a second to answer the question about the fax. That's not time that's practical to capture. Okay, but if you remember back our LoJack guy, 5 minutes a day was enough. That was time that needed to be captured. All of those security check cases where they're looking in the bag, we're talking about 1, 2, 3, 4 and 5 minute questions. I mean, whatever, where they have to wait. And that's time that potentially is going to be covered. Hang on, sorry, now I'm burning up. Are you guys hot? See, at some point it was the right temperature, but okay, maybe it will. At some point between you being freezing and it being hot now, it was the perfect temperature, so we all got to enjoy that for like 4 minutes or however long it lasted. At any rate, de minimis time, be careful with that because really we're talking about, seconds rather than minutes typically. Okay, so that finished up the hour part. What time do we actually have to pay for? Okay, how do we capture that time in the timesheet and so forth? Now we get to the wage part. Okay, what do you have to pay? How much money are we talking about? What wage rates, what salary, when do we pay it, all that kind of stuff. So these are the big topics under wage. When does it have to be paid? What can we deduct? What can we take out of that? How do we pay it? What's the timing from a payroll standpoint of when we have to pay it? And then final paychecks, because they sort of have their own set of rules. Okay. So what wage rate do we have to pay? Currently, you have to pay no less than minimum wage. Okay, we have a federal minimum wage and a state minimum wage. Of course, in California, law most favorable to the employee is going to govern, and so we go with our state minimum wage, which is $9 an hour. Okay, it just went up July 1 of this year. It's going to go up again January 1 of 2016, $10 an hour. And there's legislation in the works right now to bump it up right after that. So we'll see where that goes. Currently, okay, minimum wage is $9 an hour. All right, so where the employee consents in writing, lodging and meals can be counted towards that minimum wage rate. Then the labor commissioner has a certain schedule of amounts you can allocate towards that minimum wage obligation. Okay, that only works towards minimum wage though. You don't get to do the lodging and meals for other stuff. All right, and be careful with the lodging and meals because that's the one I love is that that nanny that moved in to the people's house, and it's going on in LA. She's a nanny. She's going to be the live-in caregiver. She moves into the house and then quits, and so they want her, to move out. Which now she's considered a tenant, so they have to go through the eviction proceedings. I mean, meanwhile she's just there. I mean, they're eating dinner, and she's just sitting in the living room watching TV and not doing anything, not taking care of the kids. She just is living there anyway and won't leave. So be careful with the lodging stuff. I know it's the funniest case ever. I mean, literally they have pictures of the family, and there's just this woman off in the background, just hanging out in their house. They can't get rid of her. Anyway, be careful with the lodging stuff, yeah. You can use that, again, as an offset against minimum wage. But tips and gratuities can't be counted towards minimum wage. Flag rate employees and piece rate employees, that's what I just talked about, still need to be entitled or get minimum wage for any of that downtime, whether it's a rest period or a non-productive hour. And then we talked about sub-minimum wage for learners. Again, that's that first 160 hours of them doing something they've never done before. We can pay a sub-minimum wage. Sometimes you may need to pay prevailing wage, okay, if you're working on a public works project. And that's as we have higher wages that are set out by the state that say you need to pay this. Okay, travel time to a prevailing wage job needs to be paid at the prevailing wage rate. I get that question a lot. All right, hey, we've got our guy, he's working on this site. Now we're sending him to the prevailing wage job. Can I pay that travel time at our normal rate? Nope. If he's driving to a prevailing wage job, that travel time there is considered part of that job. Okay. Living wage, there are certain cities, ordinances that have been established that require a higher wage than the state minimum wage. Okay, that's when one time I'm thankful I don't live in San Francisco anymore, is when we have to pay minimum wage because they have a higher living wage. Other wage obligations, there's split shift pay. A non-exempt employee who works 2 shifts that are separated by a break that is larger than a 1-hour meal period are entitled to what we call split shift pay. That's an additional hour of pay at no less than minimum wage. Okay, so I've got a guy who's going to work from 9 to 12, and he's going to come back and work from 4 to 7. All right, he's entitled to an additional hour of pay at no less than minimum wage. But I can offset that payment. So basically, he's entitled to an extra $9. Okay, if over the course of the day he's going to make more than that extra $9, okay, I can offset that obligation by any amounts that exceed minimum wage. So if his wage rate is $10 an hour, okay, and he worked 3 hours and then he worked another 3 hours, okay, he made $6 over what he would have made had he been paid minimum wage, okay, so I can offset that $9 obligation. I only owe him $3 in split shift pay. Okay. Some of this stuff, doing the math, I'm more of a visual. I need to sit down and look at the math to figure it out. But so if you have questions, I'm happy to go over these again with you afterwards. But the idea is you can offset that obligation to pay with amounts they make above minimum wage. Reporting time pay, we talked about. If they show up and they're sent home, it's half of the shift. Okay, a minimum of 2 hours, maximum of 4 hours, okay, or a minimum of 2 hours if it's an unscheduled work day, right? So make sure if it's an off day, we get those meetings scheduled in advance. All right, deductions, okay. We just had a, hour-long seminar just on this one topic. Actually, not even on all of deductions, just on this. Just this one little piece right there, okay? That shows you how long we could really stretch this stuff out. But the idea with deductions is that you as the employer don't get to put yourself into any better position than any other creditor would have vis-a-vis this employee. Okay, I can't use the fact that I am employing you as a way to collect on loans, debts, monies that you owe me because you break my stuff, whatever. I don't get to withhold your wages as a way to pay me. Okay, I need to be like anybody else. I go to small claims court and recover the money. Okay, just like if it was somebody where you stole from them or something, and they need to come after you for that money. Okay, so we don't get to make deductions from the wages unless the employee has authorized this. Okay, typically the deductions that we see that are authorized are you can take out my health care premium, you can make the deduction, my tax deductions that you have to take out, things like that. Okay, if there's garnishments that are required by the state, those things you're allowed to take out. Okay, we've got a 401k program, so I'm going to authorize you to take out a certain amount and put it in my 401k. Those are the deductions that are allowed. Okay, if you've got an employee who says, hey, I'm going to take a loan from the employer, okay, I'm going to pay $50 back per week or per paycheck, well, that's fine. You can have an agreement. Why authorize the employer to take out $50? They write it and sign it. Okay, that's fine. They pay $50 a week, okay, and then they get fired and they still owe $250. Okay, I don't get to take that balloon payment, the balance owing on that, out of that final paycheck. I can take the $50, the amount that was owed, okay, for every period or every recurring paycheck, but I don't get to take. There's no balloon payment. There's no balance. All right. Where we see a lot of problems with deductions, okay, are the tools, equipment, stuff that doesn't get returned. And that's where you run into the problems of the employer saying, well, I don't want to pay him these final wages because he has my laptop that is, worth more than this paycheck I'm about to give him. Okay, I want him to bring that back. And there are different ways you can go about getting that stuff back. Okay, and David talked about in that Lunch and Learn, there's sort of 3 different options. There's this deposit scheme you can set up at the beginning, which doesn't really work. It's totally cumbersome. You'd have to have a bank account for every single employee and track interest, and it's really, really stupid. Knowing nothing about finance, I could have come up with a better scheme. Okay, so that one's sort of out. The other one is if you don't have any kind of authorization from the employee, there's nothing in writing, all right, and they come to you at the end of their tenure and say, here's the laptop, and you open it up, and the screen is cracked, and there's coffee poured all over it, and whatever. It's totally destroyed and not good. Okay, the way to recover for that typically is you need to show gross negligence. Okay, did they just drop it, and that's why the screen shattered, and then they were carrying all their stuff, and their coffee cup spilled, and it went all over the computer? Is that foreseeable? It's probably not going to rise to the level of gross negligence. Unless you have them on video, pouring stuff on it and stepping on it and all that kind of stuff. I mean, gross negligence is a very, very high standard. Okay, so the other option of deducting for that stuff is if you have them sign Okay, hey, I understand the depreciated value of this laptop you gave me is X amount. Okay, and so I'm going to allow you to take that out of my final wages. Typically, you want to have the person sign something up front and then sign again at the back end, which is, and I can go through those forms with you afterward. That's sort of another class in and of itself. But that's typically how you'd want to approach that. We've been doing another sort of untested but seems to be effective option. If you've got somebody who has the laptop and is getting fired, okay, you create 2 checks. These are your final wages, okay, minus the value of the laptop, okay? And here is the second check that represents the value of the laptop. If you bring us the laptop today, okay, I'll give you both checks. If you don't bring us the laptop, I'm just going to give you this one, where we've deducted out that amount, okay? The problem with this approach is that it's not legal after 5 o'clock that day, okay? Because on the day that they're terminated, you have to give them all their final wages. I don't get to withhold that amount, okay? But the employee doesn't always know that. So you can, it's a good incentive. When they see that money right there, a lot of times they think, okay, I'm just going to go get it and bring it back. Okay, it's a lot easier if you're dangling a carrot in front of them to get them to do something than if you're coming along behind saying, please give it back, please, you know, shucks, we really want it back. Okay, that's a little more difficult. Okay, something to remember though in that setup, you can't really withhold that money. If this is final wages that are owed to them, they need to get that payment, you know, at the time they're terminated, or within 72 hours if they resign. Okay, so training exams, business losses, expenses, all that kind of stuff. That stuff we don't get to take out. If this is something that is a loss that the employee incurs, okay, because they are doing your work in the course and scope of their employment, they need to be reimbursed from that. Okay, they're driving their car, all right, mileage, gas. They're incurring those costs on your behalf. There's Labor Code Section 2802. You absolutely need to pay them for, you know, those expenses. All right. I had a client a couple weeks ago that said, well, we have this program where our part-time people get, you know, a special, they get $25, this expense allowance, and then our full-time people get $50 expense allowance, and so we don't worry about getting the receipts or anything. I thought, huh. So if I'm a part-time person and I come in with my receipt, I just spent $100 on widgets for the company, okay? I'm part-time and I get $25 back. You know, that's not fair. You cannot do that, okay? You can have extra per diem amounts you want to give people or bonuses or other payments like that, but if this is an expense, the employee comes to you and says, I incurred this expense, you need to pay it, okay? If it wasn't authorized, we write them up, okay? We can punish them, but that's something you're going to need to pay if they can show. All right. This doesn't mean that your employee gets to go out and buy themselves, you know, a new SUV and come in and say, well, I'm going to drive my car occasionally for you, so here's my, you know, car loan, and in 5 years you'll have it paid off for me. Okay, that's not something that's going to fall under that. This is something typically that falls within the course and scope of employment. All right, deductions from salaried employees. Okay, remember when we talk about this stuff, a lot of times we're talking about, I use the terms exempt and non-exempt. Okay, exempt means you're no longer entitled to overtime payment. We don't care, you can work as much as you want, okay? Those exempt people are going to be paid a salary. That's one of the requirements of being exempt. It's not the only requirement. Everybody thinks, oh, if you're paid a salary, you're automatically exempt. That's not true. Okay, you need to meet a whole bunch of other requirements, all right, depending on which exemption you're going to fall under. But one of those requirements is a salary. Okay, so if you've got people who are being paid a salary, and if you've got people who are being paid a salary but are non-exempt, I have a lot of people or a lot of clients that do that, don't do it. It's a horrible idea. Okay, we just had case law that said if you are non-exempt but you're being paid a salary, that salary only covers your straight time hours. Okay, it doesn't cover any of your overtime. So if you've got a non-exempt person who's being paid a salary and they work over 8 in a day, over 40 in a week, they're entitled to additional compensation over and above whatever that salary amount is. Okay, actually that wasn't case. There was a case that decided the opposite, and then we had legislation that came in and reversed that case. At any rate, don't pay non-exempt people a salary. Okay, you're going to pay your exempt people a salary. So I'm paying my exempt people a salary, and now I want to be able to deduct from that salary. Okay, when can you deduct? We don't get to deduct based on the quality of their work, based on how much work they're doing. You know, I get this all the time. I'm like, you know, they're leaving at 3, whatever. Okay, I don't get to make wage deductions from that salary for partial day absences. I can deduct from leave banks if they've got a vacation bank or a sick bank or PTO. I can deduct from those, but I don't get to deduct for partial day absences from my salaried people. Okay, when can I deduct? Okay, if they do no work for an entire week, you can deduct a week of pay. Okay, this almost never happens though these days. People are checking email and phones and whatever. They return a voicemail, guess what? They've done some work during that week. Okay, so that's pretty rare. If you've got somebody, I had it come up for a client once, they had a guy who was put on a grand jury. And so he was gone, he couldn't access his phones or whatever. I mean, he couldn't, so anyway, he really didn't do any work. And so anyway, they deducted. But that's a pretty hard one. Where you can deduct are full day absences. Okay, full day absences, I'm the exempt employee, I don't do any work for an entire day. Again, if they're checking their voicemail or their email or something on their tablet or their laptop or their phone, then they're doing work during that day. But if they don't do any work, okay, I can deduct as long as it's vacation or personal leave. I want to, you know, move into a new house, I'm taking these days off, okay, they can deduct for those days. If it's for sick leave, if I call in, I'm a salaried exempt person and I'm sick, the only way you can deduct for that sick leave is if you have a PTO or a sick leave policy that's in place and the person either is not yet eligible to take that leave or they haven't accrued enough time. Okay, then you can deduct from their pay. If you don't have a PTO plan in place and your salaried person calls in sick, okay, we don't get to deduct for that. Okay, it's a little confusing, but that's California. Okay.
If they exhausted it, you could.
If they've exhausted it, yeah, you need to have a plan that they're either not eligible for or they've exhausted. Then you can deduct. If you don't have any plan for them for sick days, then you don't get to deduct from their wages, even if it's a full day absence. Okay. You guys good? Okay. So, you know, one thing to back up on this, I'm talking about the salaried people because they're paid that regular salary. Okay. If it's your exempt people, I mean your non-exempt people, and they're paid hourly, okay, and they don't come in, well, we don't talk about it in terms of deductions because there are no wages for that day. Okay. If you're going to burn up a vacation day or a PTO day or a holiday, you know, then there would be wages. But there's nothing to deduct from, okay, because they only accrue those wages as they actually work. Okay. Yeah.
I have a question regarding deductions for final pay.
Yeah.
Say an employee was overpaid and they made an agreement to withdraw or to have those funds removed for the next 3 paychecks.
Yeah.
If they quit, can we go ahead and take those payments for the next 3 checks or only the ones that they signed for that specific check?
Only what they signed for that specific. You're going to take a $50 from each paycheck, and they on the first paycheck say, oh, I quit or I leave, whatever. So they still owe $100. Yeah, it's the same, you know, for overpayment of wages. What you can do, and where that comes in and is helpful, if you've got an overpayment, say, and it doesn't come up as often with wages, but if you've got an employee who's gone negative on their vacation or their PTO, okay, because we allowed them to take a vacation before they'd accrued their whatever, and then they quit. And now they owed us 17 hours of vacation that they were going to slowly accrue back over the year, but, you know, they've essentially gotten additional wages. Okay, and I have one going on right now. When they march down to the labor commissioner, which is exactly what she did, and say, oh, I didn't get this, and I owed waiting time penalties, and I didn't get these wages, or these meal periods, and these rest breaks, and blah, 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 blah. Any amounts that they owed you, you can use to offset wages that they said were owing. Okay, so if they say, I'm entitled to waiting time penalties, because on the day that I left, I was not paid I wasn't paid all of my wages I was owed. Well, you got 17 hours of extra wages, so there were no wages owing at the time that you left. So you can use that as offset. So it isn't necessarily always a bad thing when they leave and having been overpaid, you know. But hopefully you're not overpaying your people, because it could be a real cost saver to not overpay your employees. There you go. Just my business tip of the day.
What if the overpayment though was a result of giving them more vacation than, you know, we paid them additional vacation? Same thing, we can't.
It's the same thing. It's just wages. Yeah, the vacation time is just like wages. Yeah, you can't recover that. And generally, it's why I don't really encourage you to let people go negative on their stuff. You know, if it's H1N1 flu season and you really want to make sure people aren't coming in sick, you know, allow them to go negative on their sick days or something like that. Then that's sort of a separate situation. But absent that, I would not encourage you to allow that negative accrual. Okay. So I had a really interesting one that came up. They had a girl who had a vacation planned. Then she ended up going out on FMLA, and then she was supposed to come back, but she wanted to take her vacation. Only what had happened was when she went out on FMLA, they had a policy you have to use your accrued paid leave before you use any unpaid leave. So she burned through all of her vacation days, comes back from FMLA, and now in 2 days is supposed to leave on her vacation that she's already planned and paid, you know, whatever, presumably paid for. But the employer said, well, you don't have any vacation left because you burned all your vacation when you were out on FMLA. And so the question was, do we have to allow her now to take this time off? Of course, if the person comes back to conditions that are different than they were when they left, then you have a problem. You may be retaliating against them because they took their leave. So if she left, and when she left, she had an authorized, approved vacation time, leave time of a week, and then she comes back, and now we say your vacation has been wiped out, aren't we now treating her differently because she took this FMLA? It's pretty interesting. So they let her take the vacation. It wasn't paid because she didn't have any vacation on the books. The question there then was, should we allow a negative accrual? And we opted not to do that because, you know. The other thing, when you allow that negative accrual, you may be setting a precedent, you know, down the road for somebody else who wants to come along. You know, oh, you only allow it for the, you know, young white men, okay? That may be a problem if you have 8 women that are asking for, you know, special unpaid leave so that they can go do their kids or whatever. Nothing against young white men, Bill. But, you know, that's the problem you run into. If you're going to have different standards for different people, then you need to be careful. Okay. So when do we have to pay the wages? Okay, we pay them on the paydays. There's regular paydays. You need to make sure you post that. Okay, and then of course there are very specific requirements as to when the wages need to be paid. For non-exempt employees, no less than twice a month. Okay, work between the 1st and the 15th, paid on or before the 26th. Works between the 16th and the end, paid on or before the 10th of the following month. Okay, for exempt employees, you can go down to once a month. Okay, but no later than the 26th of the month, and that needs to include wages through the entire month. So the 26th to the 30th or the 31st needs to be included. All right, so you can pick your whatever payroll program you want, weekly, bi-weekly, semi-monthly, okay, whatever works, as long as it falls within these parameters and they actually get their wages, you know, according to the timing requirements. Okay, when your payroll period closes, you have 7 days from the close of that payroll period to get that check to the employee. Okay, and so you set up, it's going to be every other Friday, or it's the 1st and the 15th, or however you want to set that up. Okay, we want to stay with that program. Okay, post that so everybody knows when they're going to get their wages. If the payday falls on a holiday or the business is closed, okay, you can delay it until the following day. All right, that's allowed. If the holiday falls on a Saturday, if the payday falls on it shouldn't say holiday, it should say payday. The preceding Friday would be considered the payday. Okay. If it's on a Sunday, the Monday would be considered for payday purposes. Okay, so when the 15th is on a Saturday, okay, we pay it on the 14th. When the 15th is on a Sunday, and that's our normal payday, we can pay it on the Monday. Okay. And then final paychecks we'll discuss separately because they get their own special timing requirements. Paychecks must be payable in cash on demand, okay, without discount at an established bank within the state, blah, blah, blah. Okay, these are the requirements. And that really went to, like, you know, if you're giving people, like, you know, debit cards, or not debit cards, but those, you know, yeah, like, yeah. You know, Script or whatever, right? You know, you get, you know, $50 worth of merchandise at Target, and I'm going to give you this in lieu of your wages. No, it needs to be cash. It needs to be something that they can actually use, deposit, and pull out immediately. Must be made available to the employee during the hours of work at the regular place of business on the scheduled workday. Okay, so we have this is our payday. Okay, be careful with putting that stuff in the mail. Okay, if you've got, and this question also comes up, direct deposit where employees agree in advance. The question I always get from the employer is, can I just tell everybody they have to do direct deposit because it's so much easier and so much cheaper and more convenient? No. You can give them the option of direct deposit, but you cannot force the employees to use a direct deposit system. Okay, if they want a live check, you've got to have that live check ready for them on the payday at the workplace, ready to go. Okay. If the deal is, they're on a 410 schedule and we pay every Friday and they don't come to work that Friday. Okay, what do? You still make it available at the workplace, that's fine. Okay, if they tell you, we'll just stick it in the mail to me, that's fine. Okay, make sure you get that in writing. Because if you don't get it in writing, that paycheck will not be deemed to be delivered to them until they actually receive it. Okay, if it is in writing, you can mail it to me, it's deemed to be delivered when you stick it in the mail. Okay, it doesn't seem like a big difference, but when you got a bunch of paychecks that get lost in the mail or something happens, okay, that's where we run into that problem. Wage statements. Okay, this is Labor Code 226. And these are all those things that need to be on that wage statement. Remember I told you don't assume that your wage statement is all perfect and fine and good unless you sit down and actually look at it. Okay, we have a whole bunch of cases going on right now. I've probably seen 10 of the last 500 wage statements that I've looked at that are actually accurate and have all this information. Okay, but a lot of stuff can fall through the cracks and you're trying to cram things in and we want it to be small. We want not to have 400 lines for everything. Okay, so we want to try and condense this stuff, and that's what the payroll companies do, a lot of them, and so stuff can fall off. This is what you need: gross wages, total hours work, piece rate units and the piece rate for each unit, any deductions that you take out, net wages earned. Okay, you can't just have the gross, you also have to have the net after you've taken out all the deductions. Inclusive dates of the payroll period. Okay, you can't just have the payroll end date. You need both dates, start and end. Okay, employee's name, their ID number, the employer's name and address. Okay, don't just have the employer's name, have their actual address. Applicable hourly rates in effect during the period. That's where most of these tend to drop off. If you've got people who are paid multiple wage rates, okay, and you pay payroll biweekly, so they're going to get a paycheck for every 2 weeks, okay? And on their paycheck, it's going to have their travel rate, their training rate, and their actual working rate, okay? And then they worked 5 overtime hours in week 1. Well, I need to have a weighted average, an overtime rate, okay, that's based on the weighted average of the training, the travel, and the work rate for week 1. In week 2, they worked 2 overtime hours. I need to have a separate weighted average rate for week 2 because their weighted average rate is calculated per week. So you end up with a paycheck that's got, 10 different wage rate lines, okay, and the number of hours worked at each rate. That all needs to be there. Okay, the silly part is they put in all these requirements so that that wage statement would be easy for the employee to understand. Okay, once you actually get all the information, all those, particularly when we talk about multiple wage rates, it's very difficult and it can be very, very long. You can have, and I've got a lot of clients where they've got guys that get sent from job to job to job. So they're working at one rate on one job site, they're working at a different rate at another job site, they're working their travel rate to get there, they're working at the prevailing wage site at this rate. I mean, they're all over the map. They may have 12 different wage rates in a given week. Okay, and then we got to have additionally the overtime rate, the weighted average rate, and then we got to have those 12 different rates for the following week, and we got to have that weighted average. I mean, you're going to have a wage statement that's, this long, all right? You can have a little thing that references, please see attachment or something along those lines. Typically, that information is supposed to be contained in that wage statement, okay? They don't want that employee to have to reference some other document in order to get that information. But when it becomes too cumbersome and it absolutely won't fit on the wage statement, then there's nothing else you can really do. So be careful, particularly of those hourly rates if you've got people that are working multiple rates. Okay, departing employee issues, and these are really what I'm talking about, that final wage, those final wage issues. When the employee resigns, all wages paid within 72 hours of the resignation, okay, or on that final day. You know, I'm quitting and my last day will be next Friday. You can provide the final wages on that Friday. Okay. The question that comes up all the time, we got the guy who resigns, hey, I'm going to quit next Friday, and they say, that's great, why don't you pack your stuff up and just go ahead and go now? Okay. Do I pay him as of today, or do I pay him as of that next Friday when he was going to leave? Okay. You can do either. The downside to paying him through next Friday is you pay for 2 weeks when he wasn't there working. Okay. You know, maybe it's good, you get him out. Typically employees who know they're on their way out aren't working anyway, okay? They're just stirring up trouble around the office or whatever, okay? So it may be good to get them out. You're paying for him to not work. The downside, if you stop and say, okay, fine, you go ahead and pack up, you're done as of today, that turns that resignation into a termination, okay? Because he was going to resign, but not until that Friday. So we're firing him as of this day, which may then allow him to go in and get unemployment benefits, because this is no longer a voluntary separation. This is now a termination. I mean, unless you can show some misconduct or something else that would disqualify him, probably the person's going to be entitled to unemployment. Okay, so it's, you know, there's a cost either way. Whichever cost you want to incur, it would be up to you. So that's for when the guy resigns. Okay, if they're terminated without notice, okay, all wages due at the time and place of termination. Okay, with a few exceptions, if it's a seasonal employee, okay, within 72 hours, oil drilling within 24 hours of termination, and if it's a temp employee, okay, it's at the time that that temporary assignment ends. Okay, the big case there was she was a hair model, okay, and she got asked to do a hair show one day, and then they waited and paid her at the end of the month when their payroll thing closed out, and she said, well, my wages were due the day of the hair show, at the minute the hair show ended. Okay, of course I didn't complain until all this time had passed, so I can get all the waiting time penalties. And she ended up getting like, you know, $8,000 for what should have been, you know, a $50 hair show or something. Okay, so got temp employees. If you know you're hired to work through the end of next week or through the end of the trade show, okay, or for our special event, you're going to work at the concert. Okay, when that concert ends, that's when their wages are due. Okay, so you want to have somebody there with their checks or somebody who could come to that event. Okay, a suspended employee. Okay, we put you out on leave because we're doing some horrible investigation. You know, groped someone in the coat closet. Okay, now you're on leave. You've been suspended. We're doing our investigation. We do the investigation. Here's the camera. Oh my God, you did it. I can't believe it. Okay, you're going to be fired. All right. Wages would be due at the end of that bona fide investigation. Okay, they don't get to go back and say, you were investigating this for 2 weeks, now you owe me an additional 2 weeks of pay. Okay, the penalties, these are those waiting time penalties. Okay, remember wages includes vacation, we talked about that, up to 30 working days. Okay, so it's basically up to 6 weeks of pay, and that's where we see the big, how this stuff gets so expensive. There's an exception if there's a good faith dispute with respect to the fact whether or not wages were owed. Okay, if there's a dispute as to how much, okay, that's going to still trigger those waiting time penalties. You don't get to withhold the wages until you figure out exactly how much. You pay the amount that you think is owing, okay, and then we figure it out from there. And then no balloon payments. That was going to your question. You know, if they still owe you more, you know, they've authorized a certain amount to be deducted, you can only deduct that certain amount from that final paycheck. Okay. There are other things you can do that we talked about in that Uniform and Tools Lunch and Learn. There's other things you can do to try and allow you to pull money out of that final check. If there's stuff, whether it's gross negligence or it's unreturned equipment, and you can show that, hey, you signed an authorization recognizing that you were being given this equipment, okay, you have not returned it, and here's the depreciated value, and you haven't signed an authorization, and so forth. There are ways you can try and kind of, you know, get around that. But the bottom line is, if you walk into Labor Commissioner and they say, here's my final paycheck, and they deducted this, 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 and this out, Labor Commissioner is going to say, that's not okay. Okay, they hate deductions from the final check. What they would much rather have you do is you give them the final check, and then they turn around and give you the $50 or $100 or whatever it is that they owe you. Okay, And if they take the final check and then run out the door before they give you your $100, okay, which sometimes happens, all right, then you get to go to small claims or go whatever, just like any other creditor, okay? Severance pay is not considered wages, okay? It's a separate piece. It is taxable now, though. That was a new change. But this is a separate piece. And the reason and the time that you would give severance pay is if you've got somebody who's leaving that maybe knows something that's not so great, or this is somebody who was a really high executive that you want to sort of clamp down. Okay, you don't give severance pay. Giving severance pay is not an obligation. So when you give that payment, you want to get something in return. Don't ever pay severance pay unless you're getting something back. And typically the thing you want to get back is a release, okay? And you want it to be a release that has the word including and not the word excluding in it, okay? The other takeaway lesson. But that's what you pay for in exchange. I'm going to pay you the severance package, and in exchange, you're going to agree that you won't sue for anything that happened during your employment relation. Okay, anything that you know about now, anything that you might figure out later, anything that relates to your employment, whether it was termination, discrimination, harassment, whatever the case may be. Okay, giving severance to one employee may set a precedent. Okay, if we go on and on, we give severance to everybody gets a golden parachute. Oh, here comes the Muslim lesbian, and she doesn't get it. Okay, that may be a problem. All right, so just be careful. Be careful about and particularly if you've got, and I've run into this situation before where they've given huge severance packages, okay? And then all of a sudden we've got somebody who's leaving and they come to her and say, well, here's your severance package. You're going to get $5,000. Okay, she's a pretty high level executive and she knows that everybody else has gotten well in excess of that amount. Okay, it looks like there's favoritism, it just smells funny. Okay, and when things smell funny to the, employment lawyer, whatever, you better believe they're going to smell funny to the DFEH, which is where she would go to fight that claim. Okay. Overtime. All right, I'm just going to dive into this quickly. We've only got about 15 minutes left, so we definitely won't get through all of this, but we'll get through a little bit of it. These are the big topics when we talk about overtime issues, and I've kind of touched a little bit on that when I talked about salaried versus hourly employees. Okay, so we look at is somebody exempt or non-exempt? What are the basic rules? Okay, how do we define what the workday is and what the work week is, and why do we care about that? Okay, that's critical for overtime calculation. And then special issues. When you pay bonuses and when you do a piece rate, the weighted average, if you've got people at multiple rates, all that kind of stuff. And then the options for limiting overtime. Okay, so who's exempt? Okay, your family members are exempt. That's your when you have your kids clean their room and they dilly-dally and it takes them 12 hours, well, so be it. They don't get any double time. There's no payment for them. There are the white-collar exemptions: executive, administrative, and professional. Okay, those are typically what you will hear about when you hear about the exemptions or that you come to mind. Okay, and we'll parse through what those mean, but those are all contained in each one of the wage orders. They have a breakdown: the executive exemption, what it means, and so forth. They use terms that are really vague and not very helpful, okay, but they're all parsed out in there. Outside salespeople, people that are subject to a collective bargaining agreement, okay. We just had a really interesting case where they said, if you're subject to a collective bargaining agreement, that's fine, but you're still entitled to a premium payment for all overtime hours worked, okay. And this employer was very crafty, and they decided, okay, well, we're going to define overtime hours as hours beyond 12 in a day. And the employees sued and said, well, no, overtime is beyond 8 in a day. And they said, oh no, here's our collective bargaining agreement. It says that we'll define overtime as over 12 in a day. That's when overtime kicks in. It kicks in at time and a half. Great. And the court said, that's fine. Your collective bargaining agreement says that, and you guys all agreed to it. Super. Okay. That's the single and only time that it's good to have a union, is when you have this bargaining agreement that says that there's no overtime till 12 hours. Drivers who are subject to DOT, okay, are going to be exempt from overtime. Commissioned employees, and we'll talk about that's really sort of the inside salesperson, okay, which is a separate exemption. And then we have a whole bunch of miscellaneous people who are exempted. I mean, you talk about how random this stuff. When you look at that, You can pick out, it's carnival ride operators, actors, shepherds, okay, newscasters. These are the people, who were not in the lobbying forum when the legislation was drafted because they all, get put in there. All the people who were not represented. It's pretty funny. But these very sort of specific carve-outs, okay? So those people are the ones who don't get overtime, okay? When we try to decide, does somebody fit into one of those categories, okay, and it's not as obvious as they're there operating the carnival ride, okay, but it's somebody's working in an office setting and we're trying to decide, are they truly exempt or non-exempt? This is the analysis you're going to go through. Does the position meet the requirements? Okay, does what they're actually doing meet the requirements? Okay, and there's a qualitative and a quantitative analysis. Okay, and then do they meet the minimum compensation requirements? Okay, when I say qualitative, I'm talking about the quality. What are they actually doing? Are these exempt tasks? Okay, and we saw this a lot with like store managers. I'm the store manager, so I'm exempt because I'm managing people. Okay, well, are you managing people or are you stocking shelves and checking people out and whatever, fitting shoes on people just like everybody else is? If the jobs that are actually required of that job are not exempt type jobs, okay, they aren't things that require discretion, independent judgment, and aren't higher level functions, then you're probably not going to be exempt. Okay, if your job requires this high level function, okay, I've got to oversee things and I'm making logistical decisions and tactical decisions and this is high functioning stuff. Oh, but actually I'm picking up, the marble display broke and so I'm spending the next 2 weeks picking up marbles off the floor. Okay, picking up marbles is not an exempt task. If what I am actually doing is not exempt work, regardless of what my job description says, okay, then I'm probably not going to meet that exemption. Okay, in California, we have that 51% rule. The employee has to spend at least 51% of their time actually doing tasks that are non-exempt, okay, in order to be non-exempt. All right. I mean exempt. I'm saying it backwards. Problem titles, and this is the other thing. You see employers all the time who say, oh, well, guess what? Everyone's a vice president, okay, because vice president sounds like, oh, of course they'll be exempt because they're way up on the food chain. Yeah, you can give everybody whatever title you want. That's not going to make a difference. Okay, they're going to look at what the job description actually is. Are these exempt tasks? And then you're going to look at what the person's actually doing. Okay, and are they really spending their time on those exempt tasks? And then finally, we have the minimum salary requirement. Okay, for the executive, administrative, and professional, it's 2 times the minimum wage. Okay. And then for the inside sales, it's 1.5 times what the minimum wage rate would be for those hours worked, okay? And that's what you need to make, at least that bare minimum. So every time the minimum wage goes up, just went up July 1, there's going to be a ripple effect. All of your exempt people, if that was based exactly on that minimum wage amount, are going to need to get a bump up too. Okay, and remember, the minimum wage again is going to go back up January 1 of 2016. So we've got that coming. Okay, well, maybe I'll let you guys all go because everyone's looking a little dazed and confused. And we'll dive into the rest of the overtime stuff when we start up next time. Are there other questions, though? Yeah.
On the mailing out paychecks,
Mm-hmm.
so we have them available to the employees in the office say every Friday and they never come out.
Yeah.
Don't need to put them in the mail with the written authorization?
I think if you have a written authorization, that's fine. If you've got, and where this comes up a lot is you've got an employee and okay, we've got your final wages here and they just never show up to pick them up. What do? You can't find them. They're on the run and so you don't know what address to send it to. You can take those final wages and take them to the labor commissioner and say, I'm depositing these with you. The employee hasn't shown up to pick them up. We can't find them, just so you know. That will stop the clock ticking on those waiting time penalties. Okay, so that's one way to do it. It can be a cost saver from that standpoint, but I always am afraid to send people, to the labor commissioner's office. But yeah. So if you've got, if they say, all you're obligated to do is make that paycheck available. Okay, so if they don't, but if when you cut the checks and you send some off to the job site and some you stick in the mail, if it wasn't at that work site ready for them to pick it up, then it's not going to be deemed delivered to them until they get it. Are there other questions? Yeah.
It's regarding deductions. If an employee is out on disability, like for a month, and they have deductions like health insurance or Aflac, so we've been paying that for them for that month, do we need to have like a written agreement when they come back so we can deduct what they owe?
What they owe. This is a great question. If I've got somebody who goes out on leave and I'm paying these premiums for them, okay, but now they're out on leave and maybe it's an unpaid leave, so they don't have a paycheck for me to deduct that amount from, okay, and then they come back and I've paid $500 in premiums to them, how can I get that money back? Typically, you want to have that spelled out in writing. And generally, your handbook will have a policy that says, hey, if you go out on an unpaid leave, and it's a leave where we're required to maintain your medical benefits or your insurance, okay? Where that comes up is Family and Medical Leave Act, FMLA, comes up under the CFRA, which is the California Family Rights Act, sort of the sister law to the FMLA. It's FMLA and CFRA. It also comes up with pregnancy disability. Okay, you have to maintain those medical benefits on the same terms and conditions while that person is out, even though those are unpaid leaves. Generally, we tell them during the course of this leave, you're going to still be required to pay your premium. Okay, that's all fine and good. When the employee doesn't send it in, whatever. You technically can cancel, can put them on notice. Here's your COBRA notice. You didn't pay your portion of the premium, so that's a bummer for you. Okay, that is a pretty aggressive approach. It's certainly within your rights, and I have clients who do that. I think, if it's not a significant amount of money, it's safer generally have them come back. Look, this is the portion we paid. You need to sign an authorization. This is the amount that, you're going to pay it back in $50, $100 increments, whatever, something along those lines. If this is somebody where they're going to be out for an extended period of time and you're paying a significant amount of money to cover their portion, give them a month, 2 months. Okay, we're going to have to give you COBRA notice. Here's the COBRA notice. Your insurance will be canceled unless you pay this portion, which is your premium. Okay. So yeah, that's definitely something that if you've got somebody who's looking at a long-term leave, something you're going to want to look at. Okay, it's only for those situations though where you need to maintain those health benefits. If you've got somebody who goes out on FMLA and then is never able to come, then they use up their 12 weeks, but now they're disabled because they can't come back, but they fall under the Fair Employment and Housing Act or the Americans with Disabilities Act. So we still need to provide some sort of accommodation. Okay. At some point, if they're going to be out for forever, we don't, need to keep doing that. And you do not need to maintain benefits under that disability leave type setup. Yeah.
Okay, what if an employee, if they don't have direct deposit, their money goes onto a Comdata card, which is like a debit card.
Yeah.
The employee closes their account but doesn't tell the employer that they closed their account, so the funds process through direct deposit. They normally have a direct deposit. Funds process through a direct deposit. Friday they say, oh, I forgot to tell my employer that I closed my account. I want my money on my Comdata card. Well, the money's already at the bank. Account is closed. What do you do at that point? Because they want you to automatically just pull that money back and put it on the Comdata card, but it has to be rejected by the bank first because the money's now in control of the bank.
Mm-hmm. Well, you can cut a different check to the employee and then you get the refund from the bank. Is it easier for the employer to absorb that delay time in terms of the wages? I suspect the court would say this is, for the employer to be without $1,000 over the weekend until the bank can reject it is a lot easier than the employee who's counting on the wages on this day. In terms of exposure, what are you really looking at? You're looking at 2 additional days of pay if you weren't to pay them until Monday. Okay, to the extent that the employee knows this and forgets to tell, could you say that it's their fault? Yeah, but I think you'd be pretty hard pressed to say, hey, we're a giant company and we refuse to pay. We don't have an extra $1,000 to pay this guy. Where we can go. Well, you could, I think you could do, if you can do a stop payment or something along, to that bank that says, hey, these funds are not, supposed to go here, or they're going to be rejected. If you know that the account is closed and you know that fund, they'll be rejected. That's another. The other problem you're going to run into though is if they get rejected and go back, or you wait you know, to the employee, well, there's going to be fees associated with all that. And whatever those fees are probably going to have to be borne by the employer. Because is it foreseeable in the normal course of business that, you know, there would be banking errors or mistakes or lost checks or whatever? Yes. And so courts have said those banking errors, I mean, unless you can show gross negligence on the part of the employee, are going to be attributed to the employer. So, I don't know. That's it. If you've got a whole bunch of employees that happens to, you know, and it's a whole bunch of money and you don't want to just write new checks because, you know, what if they say, oh yeah, sure, guess what? Everyone's going to tell you their account was closed, you know, the next day, and they all get their new check and then they've got their other payment. I don't know. Yeah.
We had that happen, but we also have the banks. We had somebody say my account was compromised, my checking
Oh.
account, so they gave me an account number the bank wanted, so they told me to close and we gave them a check. Luckily, we had right away that if you still get the money.
Okay, you'll, yeah.
But the bank as a courtesy still posted it, so we
Oh.
were actually out both.
Both balances, yeah.
But we had it in writing when we issue a second check, we have them saying, I understand that if for any reason this actually hits my account, I owe.
I will, oh yeah.
Is that okay?
That's yeah, that's a better option. So then you can demonstrate that, okay, we're trying to get you these wages, but they don't get to come back with, oh, well, how nice, you gave me a bonus, you know, for this pay period. Yeah, which sometimes those things get recharacterized.
And then we have, the way we wrote it, because we didn't want to have to say this next time, you know, if you get it paid or your next pay period, you're not going to
Yeah.
get a paycheck, or maybe you're going to double. It's required within, you know, verified month, 72 hours.
Okay, that you have, yeah. Well, I mean, technically they're entitled to those wages on the payday, but if,
But they get paid twice and they owe us the money back.
oh yeah, if they get paid twice, then yes. Whatever amount, you know, you can have them agree to whatever amount they're going to withhold from those future pages. It doesn't have to be $50. I just say $50 as an example, you know, but it could be the whole amount if they agree to it. All right, well, thank you guys.